Yes, madam.
For mention of item number 20,
20.
item on the daily list.
Ah,
We are waiting to get some signatures from the parties. We'll be filing the reply today or tomorrow.
have you informed the other side?
We will inform the other side. So a short date may be given.
At the request of the council, appearing for the respondent number 1, 2, and 3, comma, with information being given to the council for the petitioner. The prayer for accommodating for 2 weeks,
Short
1
date,
week?
any short date, because today or
for
tomorrow.
a
will be
week
fine.
is accepted. List the matter again on. You have data comments. Today is 17th. 25th
20,
August.
20.
Yes,
May I please allow?
Ah.
Akshay, I'd like to mention item number 43.
43.
43.
Hmm.
There's some personal difficulty today. Some accommodation is sought for. Address should be available, Malak?
You are appearing for the petitioner, okay.
On behalf of AM Boral,
Then we'll have it on when?
any date. Lord.
Friday?
Friday.
At the request of the learned counsel for the petitioner, list again on Friday. Learned APP submits that the case diary is available. Full stop, case diary be retained.
The interim may kindly be confirmed.
21st of August, we place it on the interim orders to continue.
DP of light.
Yes,
May I present, Lordship? Lordship, I beg to mention item number 40, Lordship.
1440,
40, Lordship.
yes.
Lordship, password for the day, Lordship.
At the request of the learned counsel for the petitioner, list the matter again day after tomorrow.
May I please?
Lordship.
To mention item number 52 logs.
52,
It is not listed, so it's, kindly have it.
yes.
On intent log.
Heard Ms. So-and-so, learned counsel for the petitioner. Learned APP has submitted that the CD is awaited. List again on when?
20.
20.
I'm not on intent log. It's Kamrup Nagar.
Okay.
On 20 August 2026. Yes,
Please, Your Lordship, I beg to mention item number 54.
54, yes.
There's some, we have to file an IA, but the signatures has not been yet because the petitioner is not well. So I kindly needed after 2 to 3 weeks, Your Lordship.
Have you informed the other side?
Yes, I have taken the consent.
At the request of the learned counsel for the petitioner,
Yes, Your Lordship.
who states that the counsel for the respondents have been informed, comma. List again on
After 2 weeks.
2 weeks. 7th of September.
Yes, Your Lordship.
7th September.
May I please, Your
Yes.
Lordship, I beg to mention item number 19. In this case, my lord, we have recently engaged, my lord, so 2 weeks time may be granted
For whom?
for respondent number 2.
The learned counsel appearing for the respondent number 2 submits that an accommodation may be afforded since they have been recently engaged in the matter. Full stop. List the matter again on when?
After 2 weeks,
8th of September.
oblige your lordship.
May I please, Lordship? I beg to mention item number 23. CD is available.
23,
3.
huh?
CD is available.
So,
Pass over the matter for the day, Lordship. The engaged counsel is not well.
at the request of the learned counsel for the petitioner, list the matter again on Friday. Friday. Learned APP submits that the CD is available. Yes,
Okay.
21st. Huh?
May I please, Lordship? Lordship, I beg to mention item number 37 and 38. The leading English counsel is unable to appear today. The date of period of detention is 86 days for today. Can it be fixed on 91 day? That will be 22nd.
On?
22.
Then 90 days will be complete. CD will be retained. Charge sheet cannot be submitted. Default bail.
UAPS. Lordship, this one is.
Today is 86 days. If we send back the CD, they may be able to file the charge sheet before 90 days. Your default bill goes. If you retain it beyond 90 days, your default bill stands. Because the
one is
court
a-
interfered and kept the CD back.
But Lordship, this one is a UAPA.
Huh?
They can file an extension also.
UAPA.
A UAPA.
Okay, at the request of the learned counsel for the petitioner, list the matter again on
22nd.
22nd of September. I'm not observing that the CD should be written. It is your choice. August.
22nd is Saturday.
20,
Okay.
24th.
24th,
Monday. Publish.
24th.
24.
With pleasure, Lordship. Beg to mention item number 18.
Hmm,
We have received consent from the other side.
hmm.
Consent list item number 18.
To do what? Consent for to
I'm-
do what?
I am for respond number 2.
Ah.
Sorry, I am for respond number 1.
Ah,
I am for respond number 1. It may be listed after 3.
at the request of the learned counsel, appearing for the respondent number 1, who submits that the petitioner has been, counsel for the petitioner has been informed. List this matter again after
After 3 weeks.
3 weeks. 14 September. Hmm?
My lord, and there is an interim order.
The interim order passed earlier continues.
Maybe. I just need to mention item number 32, my lord.
32.
32. It
Yes.
Call for my lord, but CD is not available. We are on interim, my lord.
Learned counsel for the petitioner is present.
Interim.
Learned APP submits that the CD is awaited. Stop. List the matter again on
For CD on 7th of September.
7 September 2026. Interim order passed earlier continues.
May I please also, Lordship, with the consent of the other side, I beg to mention item number 24, Lordship.
24. Ah,
Earlier, agenda matter for the day, Lordship. Yeah. Friday, Lordship.
at the request of the learned counsel for the petitioner, list the matter again on Friday.
Amicus curiae.
On Friday next, huh?
Hmm. But even item number 53, we have filed one additional affidavit that may
52,
53
53, huh?
additional affidavit that may be much.
Please, your lordship. Item number 26,
Hmm.
the matter may be passed over for the day.
At the request of the learned
Maybe
counsel
the
for the
25,
petitioner, list this matter again on
20,
Wednesday, huh?
24, 25.
24th of August 2026. Yes,
My Lordship, I beg to mention regarding item number 45 of daily list,
45.
45 of daily list,
Hmm.
it's not available in city.
Learned counsel for the petitioner is present. Learned APP submits that
interim
the
is there.
CD is awaited.
Interim is there, madam.
Huh?
Interim
is there.
CD on 7th of September.
List again on 7th of September to enable the learned APP to have the
Continue for
CD.
interim protection.
The interim order passed earlier continues.
Similar to in item number 46, also. CD is not available.
Same, huh?
Like interim.
7th September.
Made, please, your lordship. Similar prayer in item number 49, your lordship.
49.
49.
49 also CD not there.
49 same, huh? Order.
Confirm.
Interim is there.
So, Dhora Malat, 8th September.
8. It 8.
Interim may continue.
This one will be 8, huh? Others were 7. This will be 8.
Interim order.
Interim order continues.
Deeply obliged. May it please your
Hmm.
lordship. Lordship, I beg to mention item number 36, my lord. During pendency of this bail application, the matter has been charge sheeted.
Hmm.
I've been instructed to withdraw it, my lord, to apply for the appropriate forum.
At the request of the learned counsel for the petitioner, who submits that the charge sheet has been filed during the pendency of this bail petition,
My
comma, this bail application is closed,
My lord,
allowing the petitioner to approach the appropriate forum of law as advised.
my lord. Keep your obliged.
Item 1.
This is the second time bail application, lordship. At this stage, my prayer is that lordship kindly call for the up-to-date LCR, lordship.
Where is the earlier order?
Earlier order is at page 18, lordship. Sorry.
What was
Page
the
32
allegation?
and extra 4, lordship.
What is the allegation?
Position, lordship, under section 103 and 1182 BNS laws. One person has been killed, lordship.
Heard Mr. So-and-so, learned counsel appearing for the, you are Mr. Arfukon, learned counsel appearing for the petitioner. This is a second bail application in connection with
Fully verbal. Fully
Yep.
verbal.
page 1, huh? You'll find the details. In connection with so-and-so. The earlier bail petition of the petitioner was rejected by the order dated
Nine,
9/3/2000.
9/3/2026. Call for the scanned copy of the TCR list again on. Give us TCR দিব না TCR kan data side.
I think sessions case number 86/2000.
We'll take it from the list again on 7th,
My lord.
7th of September.
Lordship,
10th September.
10 September.
obliged.
May please, Your Lordship. So 2, 3 and
Yes.
7, my lord, they arise out of the same FIR. And in item number 3, my lord, on the last occasion, case diary was called for. But I have seen in the order that part is not there, so it has again come for the in the motion column. But my learned, I have requested my learned friend to open whether case diary has been received or charged.
Yes, they not received my lord in the morning, my lord. And
So you can saw item 3 can
whether any charge sheet submitted or not.
after some time.
3 and 7.
2, 3 and 7.
2, 3 and 7.
7.
2, 3, 7 একেলগে মাতিব লগা আছে। APP সুধিলো।
May I please, Lordship. The Lordship. The period of the completion of the investigation, Lordship, period of 60 days. The present petitioner, Lordship, in custody 42 days. And Lordship, the contraband recovered, Lordship, heroin, Lordship, 11 point, 11 point, Lordship, 42, no?
94 grams.
94 grams, Lordship.
Charge sheet is
No, not charge sheet. 42 days behind the bars, Lordship. And investigation, no
CD
further
matter,
required
next week.
investigation, Lordship.
20 and next Monday, 24th.
24th.
With another pair, Lordship,
Ah.
with all respect, Lordship, kindly say. This page, Lordship, page 17, annexure 3, Lordship. Is the gross violation of the section 47. This notice, Lordship. As per 47, Lordship, this BNSS, Lordship, it is clearly mandatory, Lordship. This mandatory provision is full particulars. But as per this notice, there is no place of occurrence, Lordship. It's clear violation, Lordship. Article 21, Lordship. I'm paying for bail, Lordship, this part, Lordship.
So he does not know where he has been arrested. The place where he has been
Yes, yes,
arrested, he does
not
not.
mentioned, Lordship.
Call for the case diary list again on the 24th
24th, my lord.
of August.
Deeply obliged, Lordship.
May I please, Your Lordship?
Mm.
If 33 days, Lordship, this petitioner is behind the bar, the case of Lordship snatching 304. Lordship will have the FIR at page 9.
Yes.
Lordship. Page 9, Lordship, is a small FIR. Lordship. Respected sir, madam, I, Sumi Das, daughter of Ojita Das, resident of Bapuji Nagar Housing Colony, Silpukhuri, would like to report that my mobile phone was stolen on 26/26 at approximately 12:50 p.m. at Kano.
You are who?
I am the brother-in-law of the suspected person, the Gokul Das. So on the pretext of loss of searching Gokul Das, police entered my house, and while Gokul Das was not available, I was kicked out. The only condition that was given to me was to produce the Gokul Das before the police station, which I failed. And accordingly, instead of Gokul Das, I was arrested, and since 15/7, I am behind the bar without
Monday,
any
my
fault.
lord. Monday, my lord, CDM.
The scooter was yours.
No, lordship. Scooter was also my, the elder brother-in-law of my in-laws, lordship. Not.
Monday.
I was present at the time of purchasing the scooty. So I am aware who will be the owner of the scooter, lordship.
We'll have it on Monday.
Monday.
Call for the case. Heard Mr. J. Kalika, learned counsel appearing for the petitioner. Call for the case diary, list again on 24th.
My lord.
Six.
Obliged.
May it please your lordship.
Hmm.
My lord, page 17 is the affair, my lord.
Hmm.
And affair is of the month of May, my lord, lodged in the month of May. Now petitioner is arrested, my lord, in the month of August, my lord. And my lord, in the affair itself, it is written, my lord, it is strongly suspected that the accused person has stolen, my lord. And now, from the affair itself, it is reflected, my lord, page 17. Page 17, my lord, the third paragraph. It is strongly suspected. And my lord, now they are arrested, my lord, on my lord, 1/8, my lord. 1/8. In the forwarding report, also same thing, my lord. They are strongly 3 months of investigation has. Now he was arrested, my lord. One person, sorryful, my lord, petitioner before your lordship. And in the forwarding report of sorryful, my lord, police has stated that my lord, strongly suspected. But no, actually, my lord, these are, my lord, not stolen cattle, my lord. They have possibly, my lord, they might have brought it, my lord, illegally from my lord. But my lord, these are not stolen cattle, my lord.
They have brought it illegally, but they are not-
Illegal transportation, but transportation may be illegal, my lord. That, but my lord, lordship may kindly see the forwarding report of the accused, my lord. Same thing is written, my lord. It is not written that these are, we found the investigation revealed that these are stolen cattle. Page 19.
Friday.
Oh, my lord.
Friday.
Friday, my lord. Obliged, my lord.
Heard the learned counsel for the petitioner. Call for the case diary, list again on Friday, 21st.
Obliged, my lord.
May I please your lordship. Yeah, POCSO matter, lordship. A notice is required to be sent to the informant, lordship.
Heard Mr. Bhattacharya, learned counsel appearing for the petitioner. Also heard the learned EPP. This is an application filed under from page 1, huh? Issue notice to the respondent.
Lordship, there is a mistake done by the filing. Let me file an IA, lordship.
Learned counsel for the petitioner. Is for an opportunity to file an interlocutory application to bring on record the
Name of the informant.
informant oblique complainant in the matter. Full stop. List again after filing of the IA.
My lord.
Diplomat.
Lordship 20B2C, lordship.
Hmm?
Commercial quantity, lordship. It's ganja. Of course, it is not from my possession, lordship.
Then
Nothing was recovered from my possession. Still, they have said that I have telephonic contact with the accused person from whom the contraband was in possession. That is the allegation against me.
26 August. Call
Obliged.
for the case diary.
Obliged.
Heard the learned counsel for the petitioner. Call for the case diary. List again on 26 August.
May it please your lordship.
Huh?
A commercial quantity, my lord, TCR, my lord. 22C.
Heard the learned counsel for the petitioner. This case involves recovery of commercial quantity of what?
Cough syrup.
Cough syrup from the petitioner. First of all, for the scan copy of the TCR list again on 26th,
28, my lord.
28th of August.
Highly obliged.
May I please, your lordship? The lordship, in this matter, POCSO is there. Otherwise, it is a cross case. The victim in this instant case is the accused in the another case.
Cannot be. If it is a minor, if it is a POCSO, how can she be accused in some other case?
Now, your lordship may see the page number 23.
23.
The case was filed by my wife, your lordship.
Huh?
The wife of the petitioner, your lordship,
Against you.
against a victim of instant case. Your lordship. May see the page number 23 onwards. Your lordship.
Accused also present playing. To some places, persuade my daughter. Number 2 persuaded my daughter. Okay. Now, where is the FIR where you are charged?
In page number 17. Translated start from page number 15, your lordship. In para 5, I have narrated the story.
You have filed the FIR later on.
My lord.
Huh?
Lordship,
Later on, my
it is in para 5, I have
It
narrated.
is not
all.
a cross case, sir. Yours is a cross case.
my lord.
No, mine was registered on 1st of June, your lordship.
And
That was registered on 2nd of June.
2nd of June. The date is 29/5.
29/5, my lord, it is. Paper.
Registered 35.
Registered on 2nd, your lordship. On page number 20.
Received video received so and so and
Yes,
forwarded to OC Nagaon.
Yes, your lordship.
So outpost receives it on 30th of
Yes.
May.
Yes,
My
your
lord.
lord. That I have
Then
narrated.
there is a delay in the transmission of the records.
Yes, your lord. No, your lordship, there are, I have mentioned.
Learned counsel for the petitioner also heard. Learned APP. The petitioner is praying for bail in connection with
Nagaon PS case number.
Nagaon PS case number from page 1 and 2, huh? PS case number so and so, registered under so and so. Where is POCSO? Read with section 8 of the POCSO. Issue notice to the respondent number 2 as per the prevalent notification. Call for the case diary. List again on 27th.
September, my lord, month of, first week of September, my lord, 3rd, my lord.
3rd of September
3rd September.
2026.
How like?
Petitioner to take steps within within 2 days. Yes, sir.
My lord, one mistake, in my part.
What?
That I failed to make the party, actually, the POCSO sections was added later on.
Hmm.
It did not catch my eyes, so, I failed to make party the informant to get the bail.
Hmm.
Prior to this, my lord, if I can show, we file an FIR first, that your lordship can see at page, my lord, the type copy is page 18. And the certified copy, my lord, is at page 23. If I may read, my lord. May I read? I, Zainab Afzal, wife of Muhammad Shehzad Raza Khan, resident of house number so-and-so, 6 Mile, Gauhati, wants to bring to your kind notice that the following incident at 10:03 p.m. on 22nd June 2026. I was at my residence around 10 p.m. when Anwar Khan and his wife Himadri Pujari Khan were shouting in front of our gate. Suddenly, Anwar Khan came running towards us on first floor in front of our flat. I tried to close my main door. He tried to open it to enter and harm us, which is
Now, where is the allegation of POCSO here in the?
no, my lord. My lord, in counterblast to this FIR, my lord, we have the video clips also.
No, at page 11 is the FIR against you.
My lord, my lord.
Now, where is the allegation of your?
Later on, my lord, there is no allegation in the FIR. Later on, they brought their daughter to the police station and recorded the statement before the magistrate, adding the POCSO, my lord. That is the case, my lord. No allegation in the FIR at Annexure 1, my lord.
Page 13, my lord.
Place 13.
Page 13, my lord. It has
What is-
edit section.
Page 13,
No,
the
no,
added
added
section.
section on the basis of what?
My lord, from the parasitic 183 statement of the victim, my lord, from it is edit.
So the father lodges an FIR saying, I was there with my daughter, this is what happened. Is it not?
My
He does not say that that they attempted to do anything to my daughter,
lord,
correct?
correct, my lord.
Then 1 day, 2 days later, the daughter goes and says, no, he tried this and that and that.
My lord, here, victim, FIR was lost by the, my lord, in Anwar Khan, my lord.
My minor daughter aged
Minor.
15 years.
Minor.
So the father lodges it.
Father,
Would he not have said?
father lost, my lord.
What does he say? Causing her?
Sulit dhori loi job likhe.
Then,
Yeah.
where is the question of a minor and non-minor?
My lord, thereafter page 13, my lord.
Ah.
After the investigation, FIR, it is not mentioned by, but it was filed
My
by
lord,
the father, my lord.
my lord, the case is, had it been a
But whatever be it, Mr. Soma, without notice
Yes,
being
my
issued to
lord.
the informant,
my lord,
can I take it up?
my lord, I am filing a amended cause title today, my lord, or by tomorrow.
Ah.
My lord, till the returnable date, my lord, he may be protected.
No, no, my lord, there notice.
Till it, after that, my lord, so far as the question of granting final pre-arrest bail, my lord, lordship will definitely look into the objection raised by the informant. Till then, my lord.
No, my
Because
lord, this, my objection is there, my lord. Here,
You-
POCSO, it is there.
No, 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 no.
Notice will.
It is,
come,
my lord is not a, this court is not a post office, my lord. The FIR itself says, my lord, it was not there. It was a afterthought theory, my lord. The whole story was afterthought. My lord, there are video clips. Police has seized the video clips. Case diary will reveal everything, my lord. These are abuse of the law, my lord. Clear abuses of law, my lord. Well, nothing will happen to my lord, anybody, my lord. No prejudice is caused to anybody, my lord. I'll surrender if the case diary proves it that I committed this kind of things. There are video clips. Right now, I can show the video clips. What was happened on that night? Had it happened, because the statement of the minor is pertaining to the same story, my lord. Same incident.
We'll do it this way. Have your IA filed by today. We'll have it listed tomorrow.
Pardon, my lord.
Have your IA filed today. We'll take it up tomorrow.
Today, my lord, bit difficult because of some other matters are listed, my lord. At least 12 matters in the today's list.
Day after tomorrow?
Yes, day after tomorrow.
Have it day after tomorrow. We'll have to issue notice and then we can consider the interim. It will not be proper
What I sincerely pray, my lord, the FIR filed by them
we see.
does not say per se, my lord.
That is why we are trying to have it on Wednesday or if it is possible for you, even
My
tomorrow.
lord, tomorrow morning, my lord, I will file.
File your IA and file your, we'll have it listed tomorrow. File your IA, we'll allow the IA, we'll issue the notice and we'll see. But
My lord, then again, if lordship has to wait for the response to the IA, the notice, my lord.
we'll have it before us tomorrow. We'll see.
My lord.
In the meantime, perhaps you can bring on the statement of the
My lord.
listing by.
My lord, he may be called for the case diary.
Yes,
Scan
will
copy
come,
of-
my lord. Yes, there will come, my
Because
lord.
it is
Service of notice, my lord.
No, what we are saying is if you can get the statement made tomorrow or day after, let us see what the girl has stated in the
On it,
before the magistrate, why you added up the POCSO. Yes.
along with the
If-
video clip, my lord.
Huh?
Along with the video clip.
We will not be watching video clips here, sir.
No, my lord, there's a
You will
telling
have to-
effects of the video clip.
You will have to have some confidence in the court when we say that we'll compare the statements made in the 164 statement and the FIR which has been stated. A simple comparison will show whether it was an attempt to
My lord,
violate the
may I
modesty of
submit?
a
May I
minor girl
submit,
or
my
not.
lord? I have seen the video. I have seen the video. There was nothing of that sort. Trust me, my lord. I have seen the video. There was nothing of that sort. This was an improvised story.
That is what we will see.
That is what, my lord, the video,
That is what
the
we will-
FIR and the statement of the minor girl must be tallied.
The video we are not he may have the video before us, but the story given in the FIR and the story given by the minor in the before the
186.
magistrate. a comparison of these two would perhaps reveal to this court whether it is an improvisation or not.
My,
The father says, during the fight, Kothalok, my daughter, dragged her.
Right.
Now, if the daughter goes on to say that I was pushed behind these stairs, I was taken to this place, then I was molested, it's a different story.
yeah.
If the daughter says that when I was pulled, I fell down, I was touched here and there during the melee,
Yes.
it may be or it may not be a direct attempt of a POCSO, and we may
To
consider that.
confirm both the
So
statements.
therefore, we'll have it day after tomorrow.
My lord, I may be allowed to make a mention tomorrow morning.
You
I
file your
filed the
IA.
IA. I filed the IA, my lord.
You don't have to make a mention in the morning. We are fixing it tomorrow
My lord.
at 2.
To call for the IA, my lord, I'll make a mention.
At 2, we'll have it at 2. Please have your 164 statement at least, if possible, with the video clipping.
With the video, my lord.
but in a kindly page 2, my lord. Page 2, my lord.
Of the
Petition, my lord. Petition, my lord. Here, perhaps it is section 8 of the Protection of Children from that is not,
no, he'll file an amended cost title.
my lord.
He'll file an amended
My,
cost.
that is.
ঠিক আছে।
Itu lain ada lagi.
Oh, yeah, POCSO, oh, yes.
For like first children.
Oh, yes. I'll file a comment request then.
At the request of the learned counsel for the petitioner, Mr. A. Somo, learned counsel. No, take it like this. At the request of Dr. A. Somo, learned counsel appearing for the petitioner, list this matter again at 2 tomorrow.
Well,
The learned APP shall endeavor to have the copy of the statement made before the learned magistrate.
Lordship, CD.
Along with the learned APP shall have make an endeavor to procure the case diary in the matter.
along with the video clip, my lord. Why I'm insisting.
Along with the video clip, if available.
My lord.
Yes, ma'am.
Lordship, 482 application,
Mm.
Lordship. For other sections are available, only 135 of Lordship, Electricity Act. And Lordship would be pleased to find the affair at page.
Gambling.
Lordship,
Huh?
actually, Lordship.
When were you arrested? Not arrested.
Lordship, petitioner himself is a subscriber in the APC, not for his personal use. I have detailed under what circumstance that some villager, Lordship, because to escape from the excess flood water, just to drain out those.
Which one are you?
13, my lord. That's why it is games and betting.
Yes,
I was also confused.
yes, custodial interrogation.
Lordship also pointed out that games and betting.
Is it necessary for custodial interrogation?
My lord, here.
He'll go, he'll give you all the gambling material. Let him give you all the. What is your name? What is your name?
Nurul.
Oh.
5T, Lordship.
Why are you apprehending arrest? Indeed. Munakon.
There are 4, Lordship.
Rinku, Komol, Tinku, Bablu, Debo, Bhaiti. Where are you? Why are you apprehending arrest, sir?
Lordship, 5T, Lordship, my name is 5T, Lordship, so.
Number what?
Name is.
IT of Jorhat.
My lord.
There can be so many Bhaitis in Jorhat.
Yes, Lordship,
Huh?
that's the problem.
What kind of gambling?
Teen party, man. Organized teen party game every day from 2 p.m. in a temporary service place of middle of the jungle, my lord. Forwarding, my lord. Indeed, Bogoi had employed prisoner Bogoi so and so. 500 to keep a watch on the road for police, my lord. Police vehicle, my lord. Some person also engaged to see whether police come out on, my lord. 500 rupees at 500 rupees, my lord. Last part, 10, my lord. Page 10. First, second,
They are police personnel.
No, not.
I think this Bhaiti of Jorhat was the person who was employed to. We are lying it. Heard Mr. S.J. Sharma, learned counsel appearing for the petitioner, also heard the learned APP. The learned counsel has submitted. No, this is a bill. This is a bill application under section 482 of the BNSS. Take from page 1. A perusal of the FIR at this stage reveals that no particular offense under the Games and Betting Act has been directed towards the petitioner. Full stop. The petitioner is also known with the alias Bhaiti and is a resident of Jorhat and therefore apprehends that in furtherance of the FIR dated 11/7/2026, the police may apprehend him. Full stop. The Learned Counsel for the petitioner submits that the petitioner is willing to cooperate in the investigation and appear before the investigating authority. Full stop. Call for the case diary list again on. We will have it on 11th September 2026. Full stop. In the meantime, it is provided that the petitioner shall appear before the investigating authority on or before the 26th August 2026 and cooperate with the investigation. Full stop. In the event of his arrest before the next date fixed, the petitioner shall be released on bail on furnishing a bond of ₹5,000 to the satisfaction of the learned of the investigating authority. Don't use the word learned.
Obligation.
Yes, madam.
Lordship. 482 application, Lordship. And page 10 is the FIR, Lordship. Allegation is for hooping, Lordship. From the petitioner himself is a consumer, registered consumer under APDCL, Lordship. I have annexed that copy, Lordship. This bill copy, page 13 is his bill copy. He's daily paying bill and he is having his own electricity connect. But one I have stated in para 4 of my application, when emergency situation has arisen and due to excess flood water submerged their paddy field, Lordship. That is the occasion few village members yes, hooked up, Lordship. But no such occasion that has been detailed in the FIR, Lordship. Now, Lordship, no 35(3) notice also given to the petitioner, Lordship. But they are planning to arrest this petitioner, Lordship. So may I?
Will allow him to appear, sir?
Lordship.
And but allegations are made of obstructing the public servant.
That is fine. Public servant, he did not obstruct the police. He obstructed the electrical engineer who wanted to seize the pump. Please see the FIR. When our official team attempted to take necessary action, including disconnection and seizure of the motor, he misbehaved. Do you need him in custody? Ask him to deposit the motor when he appears before you. Why do you need him in custody? Heard Mr. Som Learned Counsel appearing for the petitioner, also heard the learned APP application under section 482 in connection with so-and-so. Full stop. The Learned Counsel for the petitioner has submitted that the petitioner had used an HP pump, a 2 HP pump to take out water from the flooded fields. Full stop. She further submits that even if it is assumed that the petitioner had obstructed the team from the Nolbari Electrical Subdivision 2 from confiscating the motor, at the present circumstances, the custodial interrogation of the petitioner may not be necessary. Full stop. The learned APP has submitted that the case diary may be called for to find out, to see the further progress of the investigation. Full stop. Call for the case diary. List again on?
My lord. 14th
of September 2026. The petitioner shall in the meantime appear before the investigating authority of the case to participate and cooperate in the investigation. Full stop. In the event of the arrest of the petitioner, the petitioner shall be released on bail on furnishing a bond of ₹5,000 to the satisfaction of the investigating authority. Stop.
I'm deeply obliged, Lordship.
May I take your lordship's indulgence, my lord? Lord, what has happened, my learned, item number 32 in code number 22.
my lord.
My lord, he has mentioned 32, my item, my lord, today for adjournment.
Sorry, man.
I'm sorry to disturb your lordship.
No issues. We'll take it up.
My lord.
We will take it up.
Obliged, my lord.
মাতি দিয়ে সেইটো অৰ্ডাৰটো কেনচেল কৰাই শুনিতো হোৱা নাই অৰ্ডাৰটো কেনচেল কৰিব ঘূৰাই আনা ঘূৰাই আনা Yes, sir.
Pre-arrest bail application, Lordship. FIR page 8, Lordship, already.
Page?
Page 8.
E.
Page 8.
Ah.
Charge sheet has been made, Lordship. But the petitioners are not FIR named accused person, Lordship. Petitioners are not FIR named accused person. Charge sheet submitted, scan copies may be called for.
But learned counsel appearing for the, but Mr. A. Sharma, learned counsel appearing for the petitioner also heard the learned APP. Then you will take from page 1 of the details can logo application under section 482. Praying for pre-arrest bail in connection with page number 2. Huh? So and so. Call for the scan copy of the TCR. TCR in. Where is the sessions case number? You are asking for a TCR.
That's it.
You are asking for TCR. Where is the sessions case number?
Session case.
Huh?
Lordship, I will, later I will give you, Lordship. I will provide it, Lordship.
Counsel for the petitioner prays for the listing of prays for the listing of the matter tomorrow. Accordingly listed tomorrow. Have your details.
Blood.
60.
60.
May it please your Lordship. The petitioners before your Lordships are Indip Gogoi and Debojit Gogoi. Lordship finds the Ejahr at page 13. May I read that? If Lordship
I have seen this name.
No, what strikes me more.
I have seen this name today, a few minutes ago.
Say,
Gambling Act.
no, what happened?
Betting and Gambling Act.
I'm not on the Betting and Gambling Act, Milord. At least they could have recovered a pack of cards. 51 cards. How can there be a gambling? I put it to myself. I am not there.
We have our own doubts, Mr. Panik. There are people who can make cards vanish at the blink of an eye. Am I wrong?
But 51 cards do not even make a pack. 51 cards do not even make a pack. Not even money. Not even us. Not the vehicles are not even us. And the judicial court is giving bail one after another. Now, this is where the difficulty starts. 51 cards do not make a gambling, Milord. They cannot be a betting without money.
So therefore, that one card missing is the gambling part. That is the gambling part.
I pray Lordship will protect me.
Yes, heard Mr. S1 learned counsel.
Here, the court below has rejected their prayer.
Of course.
Saying what?
Lordship kindly peruse the page 34, my lord.
First time I have heard that will bind us.
My lord.
That will bind us.
My lord, that is.
Oh, without
that
discussing
Lordship
51
call
cards.
for my lord CD and also my lord. The material of the case there, my lord.
We have annexed materials on record that
Which is the order rejecting his bill?
Page 34. Rejecting 34 talks about other PS cases where we are involved, without mentioning that we have been acquitted in one, and the defense counsel has supported the alleged accused persons in other cases. I'll just put it on record, Milord.
Page 39.
No, is the trial going on?
No, right. We are on, this is on the bail. When we filed for pre-arrest bail, the learned jurisdictional court referred to other PS cases and says that no, we reject. Without indicating, number one, that we have been acquitted in one. The acquittal order, Lordship finds at page 23.
That is what I was seeing. There was already a proceeding.
Carrying the present case, page 39, madam. Rejection order.
What we are saying is that, page 39. Okay, we'll go by him. Page 39.
It's actually in our favor. The consideration is in our favor, but 51 cards go missing. You know. The principal thing in the game and betting is, Miller, it doesn't even make a pack of cards. That was missing. The vehicles are not ours. We have next documents on record. We were not there. Someone saying something about me, they talk bad about me. Doesn't matter.
Why do they talk bad about you in different cases? Heard
My lord,
Mr.
earlier cases are also there.
Heard Mr. Esboni, heard Mr. Esboni, learned counsel for the petitioner, also heard Mr. So-and-so, learned APP. The petitioner in the present case has sought for the privilege of a pre-arrest bail in connection with Titavur PS case number 70 of 2026 under section 112. You take it from page 1, huh? Of the Assam Game and Betting Act, so and so. Full stop. The learned counsel for the petitioner has submitted that the petitioner was both the petitioners have been are apprehending arrest since it has been brought to notice that some persons, so that one person who was arrested in a game of gambling had referred to them as being the prime organizers of a gambling operation. Full stop. The learned counsel has submitted that the petitioners were earlier in other cases named as organizers, but such allegations were brought to naught, NAUGST, after trial, and the petitioners were acquitted of the earlier allegations. Full stop. The learned counsel for the petitioner has submitted that the petitioners are not involved in gambling acts, but their name has been cropped up only because they were earlier accused in other cases. Full stop. He accordingly praised that the petitioners would be ready to participate in the investigation proceedings and cooperate in the event they are allowed the privilege of bail. Full stop. The learned APP has objected to the prayer for bail by submitting that the petitioners appear to be repeat offenders.
Page 37, madam. Page 37.
Whose names?
Parathi.
Huh?
Page 37, Parathi. Parathi. There was also NDPS case also against him.
What did I say? That the petitioners were? Appear to be repeat offenders, and in fact against one of the petitioners, an NDPS case is also pending. Full stop. I have heard the learned counsel for the parties call for the case diary list again on earliest.
My lord.
Give us an early date.
My lord. Second.
2nd of September. On the 2nd of September 2026. Full stop. Noticing that the present prayer for pre-arrest bail does not relate to the allegations under the NDPS Act, and further that the petitioners are willing to participate in the investigation process, this court is of the opinion that the petitioner should be allowed to appear before the investigating officer on or before the 21st of August 2026. Full stop. 26 and participate in the investigation process. Full stop. In the event the petitioners are arrested prior to the next date of listing, they shall be released on bail on furnishing bonds of ₹15,000 each to the satisfaction of the investigating authority. Full stop. It is made clear that the grant of this interim pre-arrest bail would not in any manner affect the other proceedings against the petitioner in any other criminal proceedings. Full stop. List again on the 2nd of September.
I'm grateful, Lordship.
Why don't we list this along with the other one?
Well,
That SJ Sharma matter, Bhaiti matter. Same case. That is why I said that I heard this name Indip again. Same. One is Bhaiti. Bhaiti is the last person.
My lord. Bhaiti is the last.
So list along with that is also AB number so and so.
My lord, it was fixed on 11/9.
11. So we'll keep it on 11/9. on 11-9 karo. And list again, list along with the AB number
1901 of 26.
26. Yes.
My lord.
May please, your lordship, a
Ah.
small prayer, lordship.
Ah.
Item number 15, lordship, can
Ah.
be day after tomorrow, lordship. I will be out of station, lordship.
Item 15.
Item 15, one
investment
five. Day after tomorrow.
Day after tomorrow koi dio.
19.
Obliged, lordship.
19 koi dio.
Right.
Yes, next.
For addition, item 16.
My senior is late to another show. Kindly pass over the matter for timing.
After some time.
17.
Please, your lordship. My lord, I am extremely sorry, my lord.
Ah.
I have prepared the brief last night, my lord.
Okay.
But after coming to the court, my lord, it has come to my notice that this remains in my chamber, my lord. So matter may be taken next Thursday, my lord.
Thursday,
Thursday, my lord.
at the request of the learned counsel for the petitioner, list the matter again on Thursday.
Okay.
20.
20.
One.
21.
May I please, your lordship?
Mm.
Lordship, here in this matter, during the pendency of this bail application, on record, my lordship, might be 2 PWs have come, but in the meantime, 3 more another PWs have been done. Total 5 PWs has been done, my lordship.
Mm.
2 independent witnesses, the father, the mother, that is the informant, and the victim girl, my lordship. My lordship, there is as of today 164 days as on today, my lordship.
That is fine. Where is the FIR?
My lordship, page 12 is the FIR, my
Page
lordship.
12.
My lordship.
May I say just one thing, last order I have flag mark is 18/3/26.
18-3. Huh?
3/26. It was fixed for evidence on 9/4/26.
Yes, I have.
She says that after that last thing which has come on record, 3 more witnesses have been examined.
No, that is not on record, my
No,
lord.
they may not be, but let us see whether the FIR indicates anything where there may be a apprehension of her, of the accused hampering the trial process. Have you seen the allegation in the FIR?
That is there and
He is a mannerless fellow, huh?
till now 216 days, that is also there.
What do you say?
Well, only one statement, being the same village, person, the statement of the victim, whether.
Victim, what does it say? What does the,
Recorded, my
That
lordship.
is- that is
State,
not-
my lord.
that is
It
recorded?
is not
Yes.
clear, my lord.
No, no.
That is not?
Yes, I'm kidding.
Have a look at the TCR.
I have seen it.
She's saying it is.
One is there, informant is there, I have seen.
Then
If victim certificate copy is there, my lord.
my lordship, please, my lord. Not underline there is. But she has implicated my lordship in the, see, I fairly submit, she has implicated my lordship. And my lordship, may kindly consider we will not temper, only 5 of the associated witness have been examined, my lord.
EW2 as per certificate copy is examined, my lord.
The allegation is not that he could commit any offense.
No.
Allegation is he was running
Hmm.
behind her.
PW2, my lord, as it is not there, my lord, I have seen, my lord. Now, yes, for the certificate copy.
It is there. We'll direct that he would not be available anywhere near the vicinity of the minor.
My lordship.
Heard Miss Swensol on a counsel appearing for the petitioner. Also heard the learned APP, Mr. K.K. Parashar, and your name is? T. Parashar. Can we say within bracket Parashar K and T? Heard Ms. T. Parashar and counsel appearing as the amicus for the respondent number 2, oblique informant. Full stop. The allegations in the FIR in the present case reveal that the petitioner had resorted to flashing himself before the victim on 2 or 3 occasions, and the informant had expressed an apprehension that his daughter would not be safe because of the accused. Full stop. The matter has been investigated and a charge sheet had been submitted under section, what of the POCSO? Charge sheet under?
164.
Under section 74/78, to take from page 2, huh? I've underlined. Read with section 12 of the POCSO Act. Stop. The learned counsel for the petitioner has submitted that the trial has proceeded to substantial extent, whereby the evidence of how many? 5 PWs.
1 to 5, my lordship.
5 PWs, including the informant and the victim, have already been recorded. The learned counsel has submitted that the petitioner had been taken into custody on 13th of January
2026.
2026. Full stop. She has accordingly prayed that the petitioner would not be now in a, there would not be any apprehension for the petitioner to hamper or tamper with the trial process, and the petitioner is willing to furnish such bond and participate in the remaining of the trial. Full stop. She has prayed that the petitioner may be allowed the privilege of a bail at this stage. What is the age of the petitioner?
29
Comma,
years.
who is aged about 29 years. Full stop. The learned APP has submitted that although the scanned copy of the TCR does not reveal that 5 witnesses had been examined till, when was the last date? 18/3.
Till 18/3/26.
18/3/2026. However, on production of the certified copies of the evidence led by the prosecution, he agrees that 5 witnesses may have been examined. Full stop. The learned counsel for the learned amicus has submitted that in the event this court considers the grant of a bail to the accused, appropriate directions may be issued for protection of the minor from any sort of from any threat from the accused. Full stop. Having gone through the scanned copy of the TCR and the statements made, and the fact that 5 of the PWs, including the informant and the minor victim, have been recorded, and also the fact that the petitioner has been languishing in custody since 31/1/2026, this court deems it appropriate to 13/1 deems it appropriate to grant the privilege of bail to the petitioner for the remainder of the trial, subject to the.
My lord, here the case diary was called for. However, my lord, I have
Seeking by the iron.
that charge sheet has already been filed, subject to what the learned public prosecutor submits. And the NDPS case number has also been registered as special NDPS case number 10/2026.
And I have to take instruction, my lord, I will take after some time.
After some time.
Let
After
it
some
be.
time. At 2.
Instruction I will take, man.
Huh? At 2?
At two.
At 2.
Yes.
Call this at 2.
Lordship, instructions were awaited on service upon respondent to.
Yes, for office 27/7/26, my lord. I guess maybe dear, my lord, because it was sent, my lord, on June last. I think steps taken in June.
Steps were taken on 26/6/2026.
Can I appoint an amicus in the matter? You are awaiting service report. We'll have it on 24th.
But anyway,
No, you may have your reports before that.
report, it's awaited, since.
Okay, heard Miss so-and-so learned counsel appearing for the petitioner. Also heard the learned APP. The learned APP has submitted that the service report on the respondent number 2 is still awaited. All those steps were taken in the on
26th of June.
26th of June 2026, full stop. This court notices that the TCR call for had already been received on 29/7/2026, full stop. Since the matter pertains to the prayer for bail, this court deems it appropriate to appoint Miss A.S.T. Parashar as the amicus to defend the interests of the respondent number 2 in the matter. The learned counsel for the petitioner shall serve extra copy of the bail application on Miss Parashar, learned amicus, during the course of the day. List again on 21st. It's bail.
21st?
21st of August 2026. Full stop. It is provided that in the event the respondent number 2 enters appearance, the same shall also be allowed. Yes, sir.
But, this case was filed, my lord, when the prosecution sanction was denied. Subsequently, it happened, my lord, that the prosecution sanction under the PC Act has been denied. Now, my lord, the question was whether under the IPC there was a requirement under 197. But I have checked up the case, my lord. But since the bank employees are not government servant as such under 197, perhaps my
Not
case
required.
may not really.
So what do we do?
I'll withdraw, my lord. The date has been fixed on 29/8 for appearance, my lord. My lord, I have instructions from my client that they will appear on that.
So we'll not say much about it. We'll
Yes,
just say. Yes, madam.
Yes. Since they are withdrawing, nothing to argue then.
When we saw the file yesterday and when we saw Mr. Dubey today here, we thought of some arguments.
So with the end result is, my lord, what I know, my lord. It's no point wasting everybody's time.
On the last occasion, he has argued vehemently, then.
No, I have not argued this. I was not present at last one. My friend
to
is
that.
referring to some other case, my lord.
No, this sanction.
Heard Mr. R. Dubey, learned counsel appearing for the. We do not want an argument on when it is not
Yes.
Yes.
necessary. Even now, we don't want it.
No, just
Heard
clarification.
Mr. R. Dubey, learned counsel appearing for the petitioner. Also heard Ms. M. Kumari, learned counsel appearing for the CBI. The learned counsel appearing for the petitioner has submitted that he is under instructions not to press the present criminal petition. Full stop. Accordingly, this criminal petition is closed on withdrawal.
Any stay may kindly be vacated.
Huh?
Any stay order granted.
There was the
earlier.
interim order that
Interim
automatically
order.
gets vacated.
What is the interim order?
Further proceeding, qua the petitioner was stayed.
It is a 2019 matter.
The petitioner, the learned counsel for the petitioner has submitted that the petitioners would appear before the learned trial court and avail such remedies in law
My lord.
as may be permissible. In such view of the matter, the available full stop. The interim orders passed earlier in this case shall stand merged with the closure of the criminal petition.
Deeply obliged.
61.
PP was required to have some instructions in the matter. You are required to find out whether the petitioner is available to pursue the matter. He is available. order dated 22/6/2026 says the order sheet reveals that the petitioner has himself stopped appearing. Accordingly, call for a report from the OC of PS Dolgaon
Because it is 2016.
whether this person is available or not. What does your report say? No report.
No report, man.
We'll have it on Friday. Have your report.
2016, man.
Giving a long date gives them a lot of time.
Yes,
They
yes,
forget about it.
Lot.
We'll have it on Friday. List again on Friday at the request of the learned APP.
My lord,
The report called for earlier shall be
alternatively, should the notice be issued for registry?
To whom?
And a complainant, to the petitioner.
if your report says is available at that address, we will close it as not
Not pursued.
pursued. If he is not available at that address, we will close it saying that he would have the liberty to make a mention if he
Yes.
wishes to pursue.
Yes.
Give us your report.
Yes.
OC report would do. Eto scan copy aise niki? Yes.
Lord, this is regular bill application, my lord,
Hmm.
behind the bars since 176 days, my lord. Perhaps else, TCR was,
They call for a TCR. They call for the
My lord,
TCR.
I am fairly submitting, my lord, I went to the registry, my lord. But the learned court below sent the TCR on Google Drive mode. But they could not arrange to make out the printout, my lord. So kindly short it. Only on 21, my lord.
What is the allegation against you?
My lord, commercial quantity, my lord. 22C, my lord.
Here will be required more.
Huh?
Otherwise, 36 and 62 was not complied by the investigation agency in this.
Shall we look it into those things now?
My lord, page number 18, 36.
Although the scan copy of the TCR had been called for by the order dated 27/7/2026, there is no office note regarding the same full stop. Oh, no, don't say no office note. Say the office note dated 13/8/2026 reveals that the scan copy has not been received till date. Full stop.
Fine.
Issue reminder. List again on
Only on 21, my lord. In fact, they have.
21st of
21st.
August 2028.
Highly obliged. The instruction has been received, charge sheet has been submitted. I don't even approach the trial court, my lord. See the regular.
The heard Mr. So-and-so, learned counsel appearing for the petitioner. The learned APP submits that the charge sheet has been submitted in this matter via charge sheet number
546 of 26, 546 of 26, dated 9/8/26.
list of the learned counsel for the petitioner, prays for the liberty to approach the learned trial court to avail appropriate remedy. Full stop. Accordingly, the bail applications are closed, allowing the petitioner the liberty as prayed for. Write different orders in all the three cases. Huh?
Deeply obliged.
Bail application disposed of.
May I please, your lordship. My lord, 55 days in custody as on today, allegation under section 21B, lordship. My lord, on
21B is a huge range. What is the range?
in the 250.
The range is very huge.
Range is very huge.
0.1 grams less and 0.1 gram more. Huh?
200 to 250. 5 to 250.
5 to 250. So what are you? 249.
Lordship, on
211.
Huh?
211.
211.
Yes,
Almost see.
almost. Lordship, on 12th, the case was fixed. CD, on that day, instruction was there that charge sheet has not been submitted. Perhaps. No, my lord. CD is not there. Lordship, on the ground of length of detention, Lordship may kindly consider 55 days.
It takes a person more than 55 days
Lordship.
to detox himself of these things.
Lordship. But Thursday, my lord.
Thursday?
Lordship, may I pray for considering one thing. The petitioner first child is date is given today, lordship, 17 for delivery, first child, lordship. Lordship, you kindly see, this is the radiological report, lordship. Today date is given and she went there, she is asked to admit, get admission on Wednesday, lordship. Day after tomorrow, lordship.
Yes, day after tomorrow morning.
Lordship.
We'll take it up at 10:30.
She's suggested to get admission day after tomorrow.
In case we consider the bail
Lordship.
on whatever grounds, we will ensure that the order is out before 12:30 and you will be able to take him home by 4:30. Will that do? He's not caring about others' children, is he?
No, no.
He's carrying around materials which will devastate homes. Why should we be so considerate
55
when it
days-
comes to him?
55 days in custody.
Ah.
And he was the driver, Lordship. A driver of a commercial vehicle. Co-accused person was there inside the vehicle. And
Dola Khalid is nearby. Why is it not coming?
and recovery was made from
Tomorrow at
NH
2. You get it tomorrow at 2.
Sir.
Tomorrow at 2. At the request of the Learned Council for Learned APP, list the matter again tomorrow. At tomorrow.
Sir.
Remind us, we'll take it up at 2.
Obliged.
The Learned Council for the petitioner has submitted that the wife of the petitioner has been advised to be hospitalized on Wednesday, and therefore the matter is being taken up with urgency.
Obliged. May I please, Lordship?
Service report, sir?
Well, service topic complete, well, respondent to also appear, my lord. Well, this case, my lord, in this case, my lord, petitioner, my lord, is written, my lord, about, my lord, 281 days, my lord.
281 days.
Yes, my lord. Now proceeding is started and my lord, 6 PWs out of 10, my lord, already examined, including victim and the informant, my lord. So, my lord, further custodial interrogation is, my lord, not required, and my lord,
No, what is it?
Till 8 examine. 8 PW exam.
How many are there?
How many look?
my lord, there are 10 PWs, my lord.
My lord, only in this case, my lord, yes, length of detention is there, but there is no delay. Everything is going on smoothly. Accused is around 50 years old. And victims are, my lord, the main victim X is, my lord, 14 years old, my lord. Other 2 victims, my lord,
How many victims?
actually 3. Other 2 are tried.
Other 2 are?
Tried. Rape with the 14 years girl.
No, there are 3 victims.
My lord.
One is a minor.
All are minor. One is 14 years. One is, other 2 are 11 years and 9 years. They are tried.
They are?
Tried.
Tried.
Rape. It was not there, my lord.
Okay.
Tried rape.
Oh, sorry, the other 2 were attempted.
Attempted. My lord, may see I have flag mark 183 of all the 3 girls and victim X PW4, victim Y PW6, third victim PW8.
I am not on merit, my lord. My lord, petitioner, my lord,
Is
On the length of detention.
has to, my lord, prepare defense, my lord. Petitioner, my lord.
Then every time there is the prosecution is over, we'll release everybody to prepare defense.
On the other hand, my lord, section 47 and 48 also, my lord, not compliant, my lord. Section 47 and 48, I have annexed, my lord, annexer 8 and 9. Annexer 8 and 9. These, my lord, are provided in the language English.
Just a minute. What do you say about 47?
47, my lord, this, my lord, notice, sub, my lord, 47, my lord, in the language of English, my lord, but no, my lord, not understand in English.
He understands English videos and he does not understand English language.
My lord,
That is,
to that part, my lord, learned, division bench headed by
Yes, my
Honorable
lord,
Chief Justice has passed one order, my lord, in my lord, regarding 36 and all others, my lord, vis-a-vis, my lord, 48. In that case, my lord, it was, my lord, clearly mentioned some conditions, my lord, whether grounds of just communicated or not, that is clear, and whether prejudice, whether main emphasis is on prejudice or not, my lord. And now it is, my lord, almost, trial is almost over, my lord. It will be, my lord, after 1 or 2 witnesses. my lord.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned counsel, learned APP, full stop, scan copy of the TCR as called for has been received. You are appearing? What do you have to say?
My lord, my submission before a lot,
Oh.
yes, is very, my lord, in the record, my lord, very bad, my lord. My lord, regarding bail, my lord, your lordship, kindly see the record. If record says bail is granted, my lord, I have no objection, my lord. Record is very bad, my lord. I have seen.
The learned counsel for the petitioner has submitted that 10 witnesses.
my,
Like 8 witnesses have been examined. How many witnesses?
my lord, as per my information, 6 witness,
6 witnesses have been examined till date, and the petitioner being the petitioner who was arrested on
my lord, 9/11/2025,
has already spent
my lord, 281 days.
full stop. 281 days in custody, full stop. The learned counsel for the petitioner has submitted that since most of the witnesses have been examined, comma, the petitioner may be granted the privilege of bail so that he may prepare his defense, full stop. The learned APP has submitted that the statements made by the different witnesses clearly implicate the petitioner, and there is apprehension that the petitioner may not, no, there is an apprehension that the bail of the petitioner at this stage may not be feasible. Looking at this stage of the trial, full stop, the learned counsel for the respondent number 2 has submitted that the victims' statements do not reveal that the petitioner may not be guilty of the allegations made. Full stop. Accordingly, he has prayed that the consideration of bail may not be made at this stage. Full stop. I have gone through the scanned copy of the TCR and I have also seen, heard the learned counsel for the parties. Full stop. Having regard to the stage of the trial, I'm not inclined to grant the privilege of bail to the petitioner at this stage. Full stop. The learned counsel for the petitioner has also submitted that the notice under section 47 of the CRPC as of the BNSS as supplied to the petitioner did not fulfill the required did not fulfill the mandatory requirements in as much as it was given in English while the petitioner is not able to understand. Full stop.
I have also referred, my lord, Bihan Kumar versus the State of Haryana.
The learned counsel for the petitioner has relied upon the
Paragraph 14, my lord.
judgment of the apex court as delivered in the case of Bihan Kumar versus State of Haryana and another, reported in 20255 SCC 799. Full stop. I have gone to the copy of the notice under section 47 of the BNSS supplied to the petitioner, and it does not appear at this stage that the petitioner at the relevant point when the notice was supplied to him had made any allegation that he did not understand the contents of the notice, full stop. The petitioner has also not been able to produce any records to show that he had made such an allegation before the learned remand magistrate at the time of his arrest, full stop. Accordingly, I do not find force in the submission made by the learned counsel for the petitioner, full stop. Accordingly, this bail petition is dismissed.
My lord, this is one such classic case, my lord, where the police is acting under the dictation of a politician. But I'll just explain how it has happened.
Ah.
A honest politician from the state of Arunachal Pradesh alleges that he has paid certain amount of money to the elder brother of the petitioner in item 30 and item 31, elder brother, paid some money to purchase some properties in Gauhati. And subsequently, he has come to know that those properties were not purchased by the brother of these petitioners. And therefore, he visited my house where we, brother and sister, younger brother and sister, along with our aging parents stay. And he straightaway threatened us that you find out your son or your brother, recover my money, or you all are going to jail. I filed an anticipated bail application before this honorable court. The honorable court, because there was no FIR, only the threatening part. This honorable court, after recording my submissions, has passed an order that no coercive action should be taken against the petitioners. Now, my lord, and a report was called from the Jalukbari police station. On the next day, a report comes that there is no case pending against these people. Petitioner in item number 30 and the father. No case pending. Accordingly, the anticipated bail application was closed. 14 days thereafter, suddenly an FIR crops up. And immediately these two teacher, father is a teacher and the mother is a homemaker, they were arrested from their home. I file a regular bail application without even considering the case diary. This honorable court gives me interim bail in a regular bail application. Subsequently, it comes up, I get absolute bail. Now, 4 months thereafter, from the date of registering of the FIR, they barge into my house. I'm using this word with all sincerity. They barge into my house at 1:30 a.m. and arrest petitioner in item number 30, that is the younger brother. All along this time, the younger brother was staying together. They did not arrest because their frustration, because they are not being able to catch the elder brother. They arrest. And they say, my lord, that we'll see how you get bail and all these things, my lord. Now, my lord, on the date of motion, this honorable court gave the learned public prosecutor a time of 4 days maximum to produce the case diary. Because I made a submission that case diary will not be produced. Because the police officers are under an impression that we can delay the bail by not sending the case diary. On the next day, when the case diary was not there, this honorable court gave me interim bail in item number 30 in a regular bail application. And my younger sister who was there at the house, she also got apprehensive because parents, then brother, younger sister who is an MTech qualified girl, she got apprehensive. She filed an anticipated bail application. Item number 31 is the sister. There also I got anticipatory bail, interim bail. And the case diary is, again, it was posted today. Now, I do not know the status of today.
Still not received, from Jalukbari.
From Jalukbari case diary is not.
This is one where this one man takes money from someone.
In both the
Are we understanding it correctly? Someone takes money from someone to buy a property. He does not buy the property or doesn't sell the property, whatever. No transaction further takes place. Why should the family be running around? Why were they arrested at all?
No, what is the malad there?
What is the allegation against the petitioners herein in the FIR?
Zero.
What is the allegation?
Zero. Entire FIR is against the elder brother. This is a classic case where some compensation is to be.
We have sent signal on 22nd of July and again on 28th of July.
Now this Mr. SKJ, we'll call him SKJ, not take his name, but we'll call him SKJ. The allegation is that it was done fraudulently with ill intention to cheat him. Where is the father, brother, mother, sister? Hmm?
No, as per the FIR allegation against only.
The transaction is not with them.
No.
No transaction with them.
No explanation also given, my lord, by the NDPS. Why not CD not given?
Day after tomorrow, the CD or we
Otherwise,
finalize it.
An interim may be continued.
At the request of the learned APP, list the matter again on day after tomorrow. Stop. The learned APP. No, the CD called for by the order dated
Initiate
22/7/2026 in BA number 2004 of 2026
and again on 27.
may be produced on that day for further consideration of the matter, failing which the will be considered on that day, full stop. The interim order passed earlier continues. I have just made a note so that you can inform them to have the CD or that
Both interim are there in both the petitions.
interim orders passed earlier will continue.
I'm deeply obliged.
Case of mistaken identity in the morning. Yes.
I am obliged. My lord, here intermediate quantity, your lordship is aware the small quantity of ganja is 1000 grams. Here, my lord, 1782 grams. 782 grams more, my lord. 1782 grams have been recovered. Now, my lord, on the last occasion, on 6/8, my lord, the case diary was available. And on that day, my lord, the petitioner was under my lord, custody for 31 days. And I, having, my lord, realized that at this stage, the honorable court may not be inclined. So I made a prayer that after 10 days, my lord, it can be considered. So as on today, my lord, 42 days, more than 2/3 of 60 days, my lord. Here, 60 days is, my lord, mandatory, the period, my lord. So on that ground, lordship may consider, my lord. Otherwise,
Today we, unfortunately, my lord, CD today we do not have. On that day we have CD, my lord. We do not have the CD today, my lord.
they ought not have returned it, my lord. They have returned it. On the last occasion, CD was there.
Call for the updated CD is the order.
Perfect.
So it has to go back, updated and come back.
Lord,
The order, last order says call for the updated CD.
Lord.
When? Tomorrow, day after, Friday.
Nahi, soega, my lord, soega. Can be tomorrow, my lord.
Monday, my
No, 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 my lord.
This week.
Tomorrow.
This very week, sir.
Tomorrow, 2 p.m.
Lord, not tomorrow. May not come, my lord.
Thursday?
Thursday, my lord.
Thursday?
Thursday, my lord.
At the request of the learned additional public prosecutor, list the matter again on Thursday. The learned counsel for the petitioner has submitted that the petitioner has already suffered
42 days as on today.
42 days of incarceration as of today.
Obliged.
Mr. Talukdar, when you say the small quantity is 1000 grams and only 700 grams above is recovered, I would say almost double has been recovered.
I oblige.
To change the color of the story,
Yes, that
it
may be
becomes
consumed, my lord.
almost double has been recovered.
Correct, my lord. I'm
Yes.
obliged.
CD received.
33, my lord, here, scan copy is received, my lord. I can put scan copy.
What? This is a POCSO matter.
Also, scan copy.
Notice not given to the other side.
Lordship, notice has been served. Upon respondent number.
How do you know? Notice was not even issued. It has been served.
Notice served, my lord.
Although heard Ms. So-and-so and a counsel paying for the petitioner. Learned APP submits that the notice on respondent number 2 has been served. However, none appears today. Full stop.
No.
Accordingly, again, any Ms. T. Parashar,
Keep us.
is appointed as the learned amicus to assist to defend the interests of the respondent number 2. Full stop. Scan copy of the TCR has been received. List the matter again on Friday. On Friday. The learned counsel for the petitioner shall supply a copy of the bail petition to the learned amicus during the course of the day.
Obliged.
No, no, it's just এটা না এটা
May please, your lordship.
Hmm.
In this matter, what had happened was that my matter is under POCSO, but as per the last order, my lord, notice upon respondent number 2 was not sent. So that is the issue. LCR has been received, my lord. We are ready to take steps today itself, my lord. A short date may be given, my lord.
Steps not taken.
The learned counsel for the
Notice it
petitioner
given.
submits
Notice may be issued.
that although the trial court records have been received, by inadvertence, the notice on the respondent number 2 had neither been issued nor steps taken in that regard, full stop. Accordingly, he prays that the notice be issued on the respondent number 2 and he may be allowed to take steps during the course of the day, full stop. Issue notice on the respondent number 2
Notice to the- Yes.
in accordance with the prevalent notification, petitioner to take steps for service of notice, for service of notice within 2 working days from today. We are giving it to you till
But next day.
this the matter again on 25th of August for report on service of notice.
25th, my lord, perhaps too early, my lord, because it will take some time to go to the office also.
But we will
First
do
we'll
our
submit to the registry, thereafter it will come to office. Thereafter we have to.
Well, we
supply
will take
post, my lord.
steps today itself, my lord. Let us try, my lord, on 25th, my lord. Because I
When were you arrested?
Arrested, my lord, on 26/5. Long back, my lord. Let us try, my lord.
There
25.
also, my lord,
28th,
sufficient materials are also there, my lord.
28th,
28th, man.
28. 2 days
Hello.
more, 28.
My lord, the petitioner is behind bars since last 8 months. It's a case of commercial quantity, my lord.
Scan copy is received, my lord.
Prosecution case is that, my lord, during the course of checking at ISBT Gauhati, this contraband was found in the possession of the present petitioner. But the case was that he was merely passenger sitting in a seat and some luggage was kept in front of his, and we merely doubtful that this luggage belongs to the petitioner and he has been detained. But he is no nexus with the objects, those have been found.
What is the quantity recovered?
43
My lord.
kg of ganja.
Just, my lord, below 45 kg.
And my lord,
It was kept in front of you.
3-4 trolleys are there.
3-4 trolleys, but these passengers always kept in any bus stand, any railway platforms. These are very usual things to be noticed, my lord. Whenever we travel in any this type of public places, there are so many luggages are kept in front of us. If it is true, so the prosecution case is likely to be proved beyond reasonable doubt before the court. Until then, my lord, I am ready to cooperate, considering the length of detention, my lord.
Your story and their story are totally different.
Yes, yes.
You left the bags and ran away.
No,
Huh? Arrested when?
arrested.
Arrested.
7/12/25.
From that ACR, it reveals, my
What
lord.
is the stage?
Yes, my lord, it's a stage of consideration of charge.
Charges has not been.
Charges is not free, my lord, charges
Since
is
last
laid
8
down.
months.
And my lord, from the material so far, my lord, it's a very clear-cut case, my lord. He was found in the possession
No,
of this
that
4
is the
trolleys, my
prosecution,
lord.
that is the story of
And,
prosecution.
he was along with 2-3
The
independent witnesses.
trolleys contained only the
Yes, because
contraband or
45
something that belonged to him also otherwise.
45
that-
kg,
that-
my lord. That is why there are 2-3
They
trolleys.
only found ganja.
And
There is nothing of my any belongings,
there
neither dress, neither mobile, it's nothing.
Seizure witnesses, both are there, my lord.
All
Is
the
it about 19 years?
19 years. my lord.
19
He's
years, my
very early in the business. He could not be-
Very early.
My lord. He has not tried anything
So
else.
in this circumstance, my lord, anybody can be arrested, my lord. Like bus stand,
So far, my
railway
lord,
stations.
Commercial quantity, my lord.
If it would
Section
be
37 is
airport
purely
case, then that
applicable
would be
here,
something
my lord.
different.
Huh?
Section 37 purely applicable here.
Applicable as per prosecution, my lord. But so far as the circumstances in this case,
Now tell us why you say that there are possibilities that you would not be held guilty or you would be acquitted.
my lord,
what are the chances that you
Chances
may,
are that have to be proved
you
beyond
may-
reasonable doubt after examination of.
so that
subsequent witnesses.
at this stage, we
But
cannot form
till
that opinion in this case.
Till that, my lord, considering the nature of case, my lord. the
37.
possession-
37, overcome 37.
Yes, that's why I'm arguing, my lord. So far as I have submitted before your lordship, that section 37 would straightly come in a case where the possession would police would seize any article directly from the possession of any particular person. But here in this case, my lord, I was a passenger. Someone kept bag, go to bathroom or here and there, any other ticket counter or here and there, or waiting for any other circumstance regarding raid of police and kept their belongings. And some other unknown person or innocent person sitting in that place can be arrested for that purpose by holding that, by charging that this article belongs to, that is an arbitrary exercise of police.
You are a resident of where?
My lord, Ghaziabad.
Ghaziabad. And you were here why?
I have come to travel my relative at Guwahati. And so, for
And
that
you were
purpose-
going back by bus to Ghaziabad?
No, no. Not Ghaziabad. That has been stated in the FIR also, as per prosecution case.
Yes. From Ghaziabad, Uttar Pradesh. Yes, yes.
No, you tell us why, what were you doing in that bus station?
Well, I was traveling to somewhere. Your lordship will find in the.
You are not telling us anything.
No.
A checking was laid. As per lordship may kindly read page 17, my lord.
Page
17, forwarding report.
17 is the FIR.
No, it is, yes, FIR.
You are still telling us, still not telling us why you were in that bus stand.
Definitely someone.
You came to visit someone in Gauhati from Ghaziabad.
Yes.
Were you trying to go back to Ghaziabad by that bus?
Ghaziabad may be treated to be his permanent residence, but
So
suppose
where was he going?
I
Why
am a
was
permanent
he?
resident of Assam. I may visit anywhere.
Why was he there in the bus stand, sir? Nothing.
Definitely, I have to, he has to, though here is not clearly mentioned, but definitely he would any traveling purpose he has gone. Bus stand, nobody ordinarily goes. Definitely, he ought to have been able through bus here and, oh, sorry. With references, I have the honor.
Please have page 23, sir.
Page 20.
23.
23 is the 48 notice. My lord. Where the case will be. 48 BNSS notice, my lord.
Signature.
It is to whom?
Is to my relative, man.
Saying what? That the relative is a FIR name accused.
Kajal Kumari.
So she is an FIR name accused?
No, man.
No. Her luggage was searched.
The 48 has to be to the relatives.
What is the ground of arrest given?
It's the ground of
Is it a correct ground of arrest?
No, my lord.
language, man.
It is not a correct ground of arrest.
I have also.
Was the relative searched?
No, no.
Was it recovered from the relative?
No.
From your possession in a bag at this bus stand?
No.
Day after tomorrow. Tell us whether this suffices.
He has avail of, my lord, what is the, my lord, he has at least, my lord, avail of this remedy, my lord.
Which remedy?
Regarding, my lord, this appointment of the legal counsel.
Where?
No, my lord. As he is, my lord, defended, my lord. That is the intent.
Where was he defended?
Today here, today and
Today
also,
here,
and also in the,
The, huh?
and
The
also,
further custody after that arrest before the remand magistrate,
yes, my lord.
was he represented?
That, no, that cannot be, my lord, because that on the date of remand, the person, his relatives are from, my lord.
So no one
Uttar Pradesh.
represented him?
Yeah, because no, that cannot be also, my
Sir,
lord, because,
Why not?
because on the date of remand,
Can't
they
be a-
cannot be, my lord.
Huh?
On the date of remand, my lord. Cannot be, my lord, because he was, my lord, he was apprehended and within 24 hours, he has to be produced before the court, my lord. And his relatives are from the Uttar Pradesh, my lord. So cannot be that.
You are not understanding the question, sir.
But my lord, the orders, if I see, my lord, the orders perhaps reveal that he was not by relatives or by legal.
$37. You are not being able to overcome.
He was going to Siliguri, my lord. It is notice from the very threshold of the FIR. With reference to subjects cited above, I have the honor to report that on today on 7 December
So
20
tell us, where was he going to Siliguri? To where?
Siliguri.
Heard learned counsel appearing for the petitioner, also heard the learned APP. The scan copy of the TCR has been received and produced. Full stop. The quantity recovered from the petitioner, allegedly recovered from the petitioner, is commercial quantity which was being carried in 6 luggage bags. And the petitioner was apprehended at the ISBT, Gauhati.
No, as we go at.
ISBT Gauhati. Full stop. The counsel for the petitioner has submitted that the petitioner was not the possessor of the luggage, not the owner of the luggage, and the same had been recovered only because he was sitting near the area where the luggage had been stored. Full stop. Therefore, prays that the petitioner may be allowed the privilege of a bail during the further proceedings in the matter. Stop. The learned APP has submitted that from the statements made in the bail petition and also in the relevant documents of the trial court records, it does not appear that the requirements of section 67 of the NDPS Act have been fulfilled to consider the case of the petitioner for consideration of bail. Full stop. Having gone through the records and after hearing the learned counsel for the parties, we are not, this court is not convinced that the petitioner has been able to overcome the mandatory bar under section 37 of the NDPS Act. Accordingly, at this stage, the prayer for bail of the petitioner cannot be considered. Full stop. The bail petition is accordingly rejected.
Trial court to proceed the matter expeditiously. That may be directed.
Huh?
Trial court to proceed expeditiously.
The learned counsel for the petitioner has prayed that directions may be issued for the trial court to proceed expeditiously in the matter. Full stop. Though such directions are not called for in a bail application, the liberty is granted to the petitioner to make appropriate prayers before the learned trial court in case there is an inappropriate delay in the conduct of the trial.
Okay.
Be disposed of.
62 and 63.
May it please your lordship, I'm appearing on behalf of TSOM. I kindly request your lordship to please pass over this matter for today and take it up tomorrow because the learned counsel is unable to appear.
So I am for item number 63, Lordship.
What do you say? You
Lordship.
are on interim?
Yes, Lordship.
Both of you on interim?
Yes, Lordship. I am in anticipatory bail, Lordship. They are,
Bail application.
Yeah.
I am for item number 63, AB number. Does it kindly see FIR, Lordship, page 17?
When was the CD received?
Did you receive, my lord, sometime back because they
Last two
either they
occasion,
are,
Lordship,
either they are not appearing, my lord,
Huh.
and your lordship may kindly see the last.
They've not appeared before the IO.
No, my lord, before the honorable court, my lord.
Mhm.
Counsel, my lord. But because that is the CD came on 23/7. So,
Okay, give an undertaking that you will not use
Lordship,
this
last two
period.
occasion, they have taken time, last two occasion.
they have taken.
But what is the allegation against them?
Due to some
My lord,
difficulties.
my lord, they are, my lord, allegedly, my lord, picking up dogs from the streets and selling it for meat to other.
Tomorrow, madam, tomorrow,
Tomorrow? Thank you.
tomorrow.
Much obliged, your lord.
Tomorrow.
Interim order, there, Lordship.
Huh?
Interim order.
Interim orders to continue list tomorrow at the request of the learned counsel appearing for the petitioner. In,
Item number 63.
you are in 60?
Three.
No, she made a prayer, so item number
62.
62.
Obliged.
In maybe. 39. CD received. And none appears for the petitioner on call.
28, man.
Huh? Learned APP has submitted that the case diary is awaited. List again on 28/8. 2026. Interim order passed earlier continues. 41.
Paper is the lordship.
Ah.
Interim is there, my lord. Perhaps CD notice.
What did the petitioner do? You want to do 40?
41.
CD awaited.
Yes, my lord.
Then CS submitted, Lordship.
RDF 75.
Mhm.
RDF is 75.
CS submitted, Lordship.
You are going to someone's house with 6 persons. Someone goes to their house with six persons. Will they sit down? What do you want to do?
My lord, petitioner is on interim. Kindly time may be fixed and he will appear in the trial court and seeking regular bail from the court.
API person and
What is it, sir? Yes, sir.
Heard learned counsel appearing for the petitioner. Also heard the learned APP full stop who submits
PS
that
law.
the
PS law.
PS law
Timely settle.
who submits that the charge sheet has been submitted by CS number
58/26
dated
dated 37/26.
full stop the petitioners were on interim bail during the investigation period full stop. It is the anticipatory bail, the privilege of anticipatory bail during the trial period has come to an end. Since the charge sheet has already been submitted, accordingly the petitioners would be at liberty to approach the learned trial court to pray for grant of bail during the trial proceedings as and when summoned to the court. May be disposed of.
Next one.
Left region. Is a AB. FIR page 10. The allegation. The victim is a boy.
We visit the city also.
I did consider paragraph number 6 and 7 of my
Of
petition
the
at page,
petition.
yes. At page 5. Paragraph number 6 and 6 and 7.
Okay.
Mm.
Material said, dear Lordship, 186 statement, he has implicated this person also. Person can be paid also. And section attracts errors.
The rape allegation is also there. Section 62. FIR, as per FIR, attempt to murder.
Huh?
Attempt to murder. FIR allegation. Last sentence.
That will come also at the end of the investigation also. At present also, whatever section is there also, that section POCSO is the main section also. And section.
No, he says that there were other persons who heard and he ran away.
Lordship.
Anybody else's statement here? Saying so?
This person's statement I have not found also.
My lord, if I have an intention this, then at the relevant point of time, if the informant and his family.
Foundational fact, something happened.
Yes.
Minor, you were present. Immediately, the court turns to you.
Allegation is there.
You admit your presence. Child is a minor.
Minor.
Then,
Is a boy.
then
Actually, I mean, actually, if my intention is there, the entire family was a tenant under the informant. At the relevant point, I ought to have committed. Actually, he took 55,000 money, borrowed money for running a business.
in order to query YouTube
47.
Here also CS submitted also.
Huh?
Here also CS submitted also.
CS number?
263/26.
Lordship, it is a case of domestic violence. Lordship.
Dated 31/7/26.
Lordship, earlier interim order may absolute, Lordship. It is a case of domestic violence.
Case of?
Domestic violence. Lordship.
Why should we make it absolute? You are beating up your wife, your client is beating up his wife. Why should you make it absolute?
42 sir.
What is the incident?
Actually, it is not my case. My friend is in hospital. He informed me for this.
Since investigation is over,
42 sir.
we are giving you the liberty to approach the trial court for bail as and when you are summoned. Okay?
Obliged, Lordship.
Disposed.
May I please also?
But the concern was last time, as my lord, whether this application is maintained or not, because the 65(1) is involved, my lord. Now I am relying on
So this case, MP Goswami has gone to the city, he is in another court after some time. also. This is
Please, Your Lordship, 482 application, my lord. This is the third time, my lord, case that he has not been received, my lord. There is an order, my lord, of 11/8/2026, my lord. This is a shortage of 85 quintal of PM Yojana rice, my lord, was detected. I am the secretary, my lord. So it is alleged that the secretary ignored the official instruction, my lord, and misappropriate that 85.644 quintal of rice, my lord.
CD.
1 quintal of rice, 70 rupees, huh?
CD we have not received also.
This is the third time, my lord. Also may produce that order of 11/8/2026, my lord. This is the third time, my lord.
Shortage may be given. Shortage may be given.
For him to appear.
My lord, may I pray for interim, my lord?
There is no other option. The last order says so in the event of non-receipt, the prayer for interim protection will be considered.
Shortage receipt. Day after tomorrow also.
Huh?
Day after tomorrow also.
Day after tomorrow. Learned APP has submitted that the matter will be taken up day after tomorrow, on which the case diary shall invariably be produced. List again day after tomorrow.
They have to come on. God bless you.
Lordship, timing, Lordship.
Huh?
Timing.
POCSO method also notice probably not served also. Yes, it is, yeah?
Lordship, my learned counsel is in another court, Lordship.
POCSO for service. 50
Have you seen the allegations? The wife is inviting the child to sleep with the accused. It has to be, the notice has to go to respondent number 2, sir.
This even not served also. Not issued also.
Have your instructions, notice was not served, should we pass an order for serving notice on the respondent number 2? After some time.
May I please, Your Lordship? Lordship, this is a 482 application. My Lordship here, along with BNS 296 section, the 31R, 31S of the SC/ST Act is there, my Lordship. My Lordship, I have filed an additional affidavit, which was called for today morning, my Lordship. On last occasion, when the matter came up, on my submission, the Honorable Court directed me to submit the transcript, my Lordship. I have, in the additional affidavit, my Lordship, stated it and even translated it, my Lordship. The My Lordship, here, the petitioner, my Lordship, the petition, what happened was the petitioner number 1 was the lessee of the market, and petitioner number 2 is the member of the Anshalik Panchayat. The one of the person, Bimanjyoti Luing, my Lordship, he was the leader. He went to that market, my Lordship, and was demanding 200, 300, 500 in the name of flood victim. These villagers and these vendors of the market, they have already given voluntarily. Even the petitioners have also given. For those vendors, my Lordship, it's a small market, 200, 300, 500 was not possible. And for which, when they objected, my Lordship, the petitioners who were lessee was also there, and the petitioner number 2, who is a member of the Anshalik Panchayat, was also there. They came forward and they stated that demands should not be made. If someone voluntarily wishes, then it should be done. And as such, they were on a heated argument. And as such, my Lordship, the petitioner number 1 was the first person who on 29/7/2026 immediately has lodged a representation before the district commissioner and has also provided. I have annexed, my lordship. Thereafter, my lordship, we have lodged a FIR, my lordship, on 2/8/2026. Subsequently, this FIR has been lodged, my lordship, on 5/8/2026 by giving the picture into a communal form stating the impleading the SC/ST Act. So thereafter, whenever last occasion the matter came up, my lordship, I was directed to give the transcript of the same transcript. So my lordship may be pleased to peruse page 43 for a second of my additional affidavit. I have stated exactly the lines. My lordship, it no way connects or carries
Page 43.
of my additional affidavit, my lordship.
Yes, sir.
মই দাদা এই ট্ৰান্সক্ৰিপ্টটো কৰিম, ভিডিঅ'টো কৰিছিলোঁ 43. May I read, my lordship? 42 will be, my lordship, the Assamese of England, 42. আৰু তেখেতে কৈছে যে এখন মদৰ বজাৰ এখন তাত অনুষ্ঠিত হৈ বুলি কৈছে। এখন বজাৰ অনুষ্ঠিত হয়, সেইখন আমাৰ মিচিং সম্প্ৰদায়ৰ বজাৰ হয়। আমি সৰু কালৰ পৰাই সেই বজাৰখন মিচিং সম্প্ৰদায়ৰ লোকখিনিয়ে তাত এখন বজাৰ সাজ পানীকে আদি কৰি বিভিন্ন গাহৰি মাংস, মাছ, অন্যান্য ৰুটি, ভাত আদিৰ ব্যৱসায় কৰি তেওঁলোকে পৰিয়াল পোহপালন দি আছে। যিহেতু সেই মানুহখিনিৰ কাৰণে কোনো নিৰ্দিষ্ট চাকৰি নাই বা কোনো ব্যৱসায় তাত তেখেতসকলৰ ব্যৱস্থা নাই, আজি সেই মানুহখিনি তাত কৃষিজীৱী মানুহখিনিত হওক বা মিচিং সম্প্ৰদায়ৰ মানুহখিনিয়ে হওক, সেই বজাৰখনক ধৰিয়ে সপ্তাহটোত কিছুমানে গোটৰ ধাৰ মাৰে, কিছুমানে স্কুলৰ বিদ্যালয় ফিজৰ পৰা আদি কৰি যি বিদ্যালয় যোৱা খৰচা, যাৱতীয় টিউচন ফিজ তাৰ পৰাই তেওঁলোকে আহৰণ কৰে। কিন্তু তেখেতে সেই বজাৰখনকো আক্ৰমণ কৰিবলৈ গৈছে। মই আজি কিছুদিনৰ পৰাই মই অনুভৱ কৰিছোঁ বা মই বিভিন্ন মানুহৰ পৰা গম পাইছোঁ, বিমানজ্যোতি লুইঙে উক্ত বজাৰখন সম্পূৰ্ণৰূপে বন্ধ কৰিবৰ কাৰণে এটা প্ৰচেষ্টা চলাই আছে। যিহেতু সেই বজাৰখন বন্ধ হোৱাৰ লগে লগে ব্যৱসায়সকলৰ যথেষ্ট অসুবিধা সৃষ্টি হ'ব। আৰু যিহেতু তেখেতসকলে কৈছে যে বজাৰখন চাফ চিকুণ নকৰে, কিবা নকৰে, আপোনালোকক তথ্য সহকাৰে মই দিব পাৰোঁ, GPS কেমেৰাৰ প্ৰতিটো সপ্তাহৰ বজাৰ চাফ চিকুণ কৰা ফটো আমাৰ আছে। This was the exact version that was in the video, my lordship, which has been converted to my.
This is said by whom?
Petitioner number 1. After in the press meet, which was in the Facebook, my lordship, and which they have converted it into page 16, my lordship. May I read, my lordship, page 16, last paragraph. Page 16. May I read, my lordship? With great sadness, it is to inform you that when to give a rebuttal with regard to all the organizations in press conference stated publicly through social media that a part of the bazaar is given for the missing people to sell Haspani pork roti, and along with it has been stated that by selling wine, their children are taking out the expenses.
Yes, what is, how does it come in?
So I have given that statement of the complainant, lordship. Does not, whatever he has submitted before the IO, lordship, it does not reflect that motive, lordship, his motive to insult that.
There is no, hard Miss Borough Learned Council is paying for the
Petitioners, my lordship.
petitioner,
2 petitioners, my lordship.
2 petitioners. Also heard the learned APP. Stop. The transcript of the video has been placed before this court by way of an affidavit, and the learned APP has also placed before this court the statement of the complainant. Stop. On a perusal of the documents produced both by the petitioner and the learned APP, this court is of the considered opinion that the petitioner can be granted the privilege of an pre-arrest bail. Pre-arrest bail. You say like that, you say it like this. Considering the materials on record, this court is of the considered opinion that the petitioner should be granted an opportunity to appear before the investigating officer to participate in the investigation. Full stop. Accordingly, the petitioner shall appear before the Ayo on or before the 26th of August 2026 to participate in the investigating process, full stop. List the matter again on 11th of September 2026.
Again, then we have to again update the CD lordship. Or
Would they say? Again on 11th of September 2026, on which date the learned APP shall inform the court whether the petitioner has appeared and participated in the proceedings or not. In the interim, if the petitioner is arrested, he shall be released on a bond of rupees 5,000 with 2 sureties of the like amount to the satisfaction of the investigating authority. Full stop. It is made clear that on the next date, the learned APP shall inform the court regarding the participation of the petitioner in the investigation process, and the further case diary may not be necessary on the next date.
Oblige, my lordship.
Yes. Have his statement recorded. Tell us he has participated. We'll close it.
My lordship. Oblige, my lordship.
Kindly see the last order, man. I have only told one. Before I kindly come to page 13, madam.
1-3.
1-3, madam.
Yes.
And the address of the accused and the informant is very much important in this case, my lord. Kindly see informant Malek, my lord. He is from Khetri. And I am the accused number 1, Monzirul. He is from Mayang, my lord, Morigaon. And so far the 3, 2, 3, 4 is concerned, but they are also from the Khetri, my lord. Now the allegation is at page 14, my lord. May I read, my lord? This is to inform on 1-4, my lord, personally, the FI is filed on 17/4/26, my lord. And incident is of 1/4/26 to 4/4/26, my lord.
Just a minute. 17-4 is the FIR.
FIR.
Incident is of?
Is of 1/4/2026 to 4/4/26, man. Now the allegation is that this is to inform you that on 1/4/26 at about 3:30 PM in the evening, the above mentioned accused number 3 and 4, the accused number 3 and 4 from Khetri, madam, namely Asima Khatun and Moina Khatun, came to my residence and lured my 15 years old minor daughter by saying that they would purchase her clothes and took her away forcefully in a passenger vehicle to Jagirut. Taking advantage of my ill health, along with my minor daughter so-and-so, my 10 years old son so-and-so was also taken away by them. However, they kept my minor daughter so-and-so and sent back my son from Jagirut. Getting this information from the mouth of my son, we accordingly searched and asked the accused number 3 and 4. However, no information could be obtained. On 4/4/2026 at about 10 PM, my daughter called me over phone from some other person.
Understood then.
Now at the second paragraph, this is important, my lord. Immediately, I, along with my wife and one foreign hailing from our village, got back my daughter from the place. From my lord. From Mayang.
Mayang.
Later on, from my daughter, I came to know that the accused number 3 and 4 took my daughter in a vehicle from Jagir and kept her in a house of the accused number 1 from Mayang. Monzirul, that is the present petitioner, the accused locked my daughter so-and-so in a room and sexually assaulted her for 3 days. But this is the allegation, my lord. Now, one of the accused, my lord, accused number 3, that is Maina Asima Khatun, has been arrested. The her forwarding report is page 22. Can you see the ground of arrest? The victim on her statement under section 183 BNSA said that the arrested accused woman called the victim to her house. The victim house is at Khetri. Victim house is at Khetri, and the so far the Asima Khatun is concerned, her residence also is at Khetri. And the informant says the victim was subject to sexual assault at Mayang. If today the victim make a statement under section 183, then also it is not believable. Where the accused Monzulu was also present and he forcefully made so-and-so with the victim.
That's the accused called the victim to her house. Called the victim to her house.
And page 23, the accused address is shown. Musamad Asima Khatun, Mohammed no so-and-so, PS Khetri. Now, can you see the section 482(4)? And 1/4/2026, I was on my way from Chennai. Still, I am residing at Kerala.
You are Monjurul.
Yes. I have annexed the train ticket
You were traveling to or from?
from Kerala to my home. I boarded at Chennai on 1/4/2026, and I arrived on 3/4. So how can the incident can be happen? I have this time I am taking the tree of LEB melon. And phase 21 melon, I have annexed the train ticket also. It's a
What do you say?
Yes.
42(4).
The offense is involved 65 melon. Now 482(4) melon says when the anticipated bail application is barred. The word has been used melon. Nothing in this section shall apply to any case involving the arrest of a person. This has been interpreted by the Supreme Court in several cases. On accusation of having committed. If I have committed, then only the 482(2) is not a maintainable. An offense under section 65 and subsection 2.
On accusation of having.
Yes, but that has been interpreted. If there is a allegation, prima facie allegation that I have committed the offense, then only the
There is an allegation that you have committed it.
no, that's
The allegation is there.
That's why I am trying to satisfy my lord, that no such incident was occurred, my lord.
No, when the allegation is there, I cannot take up an AB. What to do? When the allegation is there, I cannot take up the AB.
Now, my lord, there is some judgment, my lord, which says, my Supreme Court judgment, but this section 482(4) is parameter to, my lord, section 18 of the SC Act also, my lord. The same,
Show us that we can take it up.
Yes, my lord.
If there is an allegation, we can still take it up. Show us that.
Before I kindly similar schedule and schedule type act.
Shall apply to
Section 18 of the SC Act, kindly similar. The word is used similar, my lord. Dada.
read it. As per section 18 of the
Yes, but nothing in the section 438 of the
shall apply in relation to any case
shall apply in relation to a case involving the arrest of a person on accusation of having committed an offense under this act. The language is similar, my lord. Now, this has been interpreted in the case, my lord, of Shahjan Shakira, my lord.
Yes.
Now, page para 7, my lord. The question has been framed, my lord. Para 7, sub-para 8, my lord. Now, the question is whether the offense under section 3(1)(r) will be attacked in the absence of reference to the case status of the second as per in the news and so on. So, in my sorry, that. No. Right, it is after para 19 minutes. next page, my lord, to whether the section 18.
How can 18 come after 19?
Yes, ma'am.
How can 18 come after 19?
My excuse is what, ma'am. Whether section 18 Act impose an absolute bar on the ground of anticipation in the case
Where?
said act. Thereafter, my lord, kindly come to my para 25 minutes. The constitutionality, my lord, got it, my lord. The constitutionality of section 18 of the Act fell for consideration code in the state of so-and-so. The salience essentially was on the following ground. Article 18 is a variety of Article 14 as thus benefit so-and-so is available to an accused offence under so-and-so, but the same is not available for an offence under 1989. Section, this is the question adopted. Now, the respondent in the aforesaid case has filed a petition before the High Court of Madhya Pradesh challenging the constitutionality of a certain provision of the Act. Although the High Court negated the same part of the salience, yet it held that Section 18 Act was unconstitutional as it was violated by Article 14 and 20 respective of the Constitution of India. The aforesaid decision of the High Court was challenged before this court, which allowed the appeal and held that Section 18 of the Act cannot be considered as violative of Section Article 14 and 20 respectively of the Constitution. It was held that the offence enumerated under Section 1989 falls into separate and special category. Court also considered the Article 17 of the Constitution, which expressly deals with the abolition of untouchability, for which is practiced in any form, and took the view that the offence enumerated under Section 3(1) of the Act 1989 arising out of the practice of untouchability having the same, it was held that Section 80 so-and-so does not violate this Article 14 of the Constitution in the any manner. Now, para 80, on this, as per Article 20 of the Constitution, it was held by this court that all
Please come to para 35. Let me help you.
Thus, the decision in the Prohibitions so makes it abundantly clear that even while upholding the validity of the Section 18A of the Act, this court observed that if the complaint doesn't make out a prima facie case, I'm harping on this, my lord.
You were?
Yes.
You want us to help you?
Yes, my lord.
Yes.
For applicability of the provision of the Act 1989, that the bar created by Section 1818A shall not apply, and thus the court would not be precluded from the granting period as well to the accused person. Oh, then, my lord.
Yes, sir. What do you say?
Now, para 36, my lord.
Special Act, my lord, where, but as per the code, my lord, very specifically two sections are inserted, my lord. That specifically barred, my lord, 65 and 70, my lord. And your lordship will find in several other special acts, my lord. May it be, my lord, Civil Caste Civil Tribe Act, and also under UAP Act, also under NDPS Act, my lord. There are certain bars, but that all have been interpreted by the Honorable Apex Court that regarding the merit, my lord. But there, my lord, it is not barred by any code, my lord. But now, my lord, this code, my lord, specifically barred it,
This
my lord.
code is barring it.
Yes, specifically.
In the case cited by him, the special act barred it,
Special act barred it.
whereas there was no bar in the code. Therefore, the code was held to be applicable and to be read to that extent.
That is my 1%.
And in this particular case, the code itself, which gives you a right to prefer a pre-arrest petition,
Very clear.
that itself is barring you.
Act
That
itself.
we will not go by 65. 65, if it is 65,
Specifically barred.
this code will not apply.
482(4), my lord. The word has been used, my lord, and my lord. My lord, 65(1) and 72, my lord. Earlier,
So
my
they both should be there. Your argument is both should be there.
65 and 70.
But it should be or, my lord.
If it is or, then anyone present, you will not. But if it is and, unless and until both the allegations are there,
It cannot be, my
there will
lord.
be no bar.
It cannot be, my lord. It should be or, my lord.
Should be. But if he's traveling that day from a certain place,
I am not going on the merit part, man, because if it is applicable, if your lordship goes into merit, then the lordship has to either allow or dismiss. But whether it lordship can take it up, that is the prime issue, before that. But in SCSC, your lordship will find in UAPA.
We find force in your argument.
UAPA,
What was
in NDPS also. they
what
have-
was interpreted by the courts to say that special courts, if they prevent anyone from approaching the court for a pre-arrest bail, because the court does not bar you, you can approach. So here now the court bars you.
Court bars.
So your reference to this case
Court is gonna very.
Kindly say the bar has been imposed, my lord.
by the code.
Yes, my lord. In SCSC also, acts also, my lord.
The act had said that you cannot move for a pre-arrest bail.
Yes, my lord.
Right? It was not the code itself. This BNSS says, if it is 65, I will not apply. I will not come there. Then what to do?
Specific.
So section 80 also same, my lord. This.
Section 18 of the Act, kindly
Yes,
understand.
my lord.
Section 18 of the Act says, this code will not apply to me. Yes? So, court says no. You have to look into the merit and then decide whether it will apply or not. An Act cannot bar what is given by the code. Code now says, I will not go there. Can you drag it there?
If I make out a primary case, that's why I am.
Can you drag it there?
But that.
You have to make it that application under 482.
Yes, madam.
Code says, my 482, you will not use there.
That's why.
Then what to do?
This husband discuss the history of the antecedent bail.
All said and done. That is because the Act barred it.
Yes.
Not the code. The code did not bar it. Here the code is barring it. There it is, please don't come to my house.
It is
That section, that the special act is saying, Mr. CRPC, don't come to my house. Court says no. If there is a necessity, he will go to your house.
That's my one.
Here, BNSS is saying, I will not go to their house. Can you drag it?
Rather, I in page 30, my lord, the antecedent bail was considered by this court, my lord.
Huh?
Yes, my lord.
That's one example I will give, my lord. In NDPS, my lord.
Huh?
There is a section 32.
But
which
page
says
30,
that,
kindly see, my lord.
once convicted, cannot be, that sentence cannot be suspended. There is a bar, but there is now, my lord, NDPS sections are, sentences are suspended.
Suspended, yes.
Page 30, my lord, kindly
But
see,
it,
this
my lord,
exercise has been done by this honorable court, my lord.
And allowed.
Allowed, my lord. Nothing was found against them, my lord.
Huh?
Even it is barred, my lord, it should not have been granted, my lord.
In the same case.
Yes, my lord. Page 28 is a AB, my lord.
may not pointed out, my.
Huh?
No, not my fault, my lord. Page 20 is a AB, my lord. So, but the other accused is concerned, my lord.
Without that part being considered. We'll come back at 2. Let us think over it. Yes, sir. Something urgent.
Small query in item
Yes.
59.
59.
In this case, Lordship, learned amicus curiae, he is absent today.
Sir, and Madam is not well today.
Ah.
Hearing,
Lordship, it may be.
hearing part,
Hearing,
last second hearing.
last item.
Do you,
Next week, my lord, the
at
Monday.
the request of the learned counsel for who appears for the amicus, comma, who is stated to not to be in good health today, comma, list this matter again on next Thursday
24, Lordship.
on 24th of August 2026.
All right.
A2 after lunch, madam. So Mr. Botagur will give you a choice. Withdraw, dismiss or pending.
Well, let me try, my lord. It will be pending, my lord. For some time, my lord.
Pending, you will suffer.
I'll try, my lord.
All your questions answered. So we can dismiss it right now.
Sorry, I've gone for this husband also, my lord.
Which one? This one?
Yes,
That I've given you?
No, I have, my lord.
The one that I have given
Yes,
you?
ma'am.
What does the end say? It will be the others who are not charged under section 65 can approach the court and be granted, and the bail can be considered.
But
the person against whom the specific allegation is there of rape, he is debarred. I am bound.
But the word having committed, that was not discussed.
Everything discussed.
Give me some time.
Allegation of having committed. You cannot take out the word having committed from there. It is one phrase. If you break down the sentence with commas,
Yes, ma'am.
to give a meaningful, to give it a meaning, to give every phrase a meaning, then it has to be broken up on allegations of having committed.
Yeah.
Have a look day after tomorrow.
Yes, ma'am.
Huh? Only in that. We think your questions are answered. List day after tomorrow at the request of the learned counsel for the petitioner.
That's why I am not harnessing this supplement.
Huh?
That's why I am not harnessing.
You should. Why will you not? Is it for us to go inside and look?
I thought it was not discussed regarding the word arrest and the having committed. That's why that was not discussed, my lord.
No, the entire sentence has to be read. There is common.
But that's not discussed in this.
No, we can add that sentence and we can finish it off. No problem. There has to be an allegation.
Yes.
Commission would become a case for conviction.
Yes.
So till the time the conviction comes, it is always an allegation.
Yes.
Even after 313. Because in the judgment it has to be discussed. What is the effect of the 313 explanation, is it not?
Yes.
So after 313 also it remains. So it has to be the allegation, not the.
That charge sheet,
Ah.
they took instruction with the
Charge sheet file, ma'am.
charge sheet file. So ideally, we should approach there and then come back. Well, can it be like this? I'll just make few submissions which can be recorded and remanded it back.
What are the submissions?
Is that, my lord, 36 notice is not attested by any of the witnesses. This is my submission number 1. Submission number 2, 48 notice was not given to any of the relatives, apart from the merit of the case.
And your statement that you had furnished a particular name?
Name
which should be given?
My lord, my father's name, my detail, address, everything appears in the forwarding report.
No. 48 says nominated.
Nominated.
Not identified. You may nominate anybody in the world.
Now, my
Your
lord.
father may be on very bad terms with you. Nomination.
Now, my lord, situation A, that they have sent it to Mr. X, and I take a plea.
You nominate nobody. What happens then?
Now, my lord, then there should be something on the record because the burden is on them.
Your allegation has to be there that I nominated. First your assertion.
Because the burden is on them.
First your assertion. I nominated. It was not sent. I approached by a representation. It was not disposed of. Therefore, a repetition. Is it not?
But prima facie, if it is not, let them discharge the burden, my lord. If they say that I have not nominated, then perhaps the burden comes on me to prove that I have nominated somebody.
You are making an assertion. It will be to your knowledge whether you made an assertion or not.
But my lord, when I made an assertion.
When? Where? That is what I'm asking you.
That is, that 48 notice was not been.
I am asking you, I nominated and it was not sent.
Para 6, my lord, nominated word is not there that I have.
Is it? Where is the 48? Kindly see 48,
Yes,
section
yes,
48.
48, my lord, that any person nominated by him, my lord. And I say here that it is not sent to any of the persons. But yes.
Any of whom? How can we trace out who are your friends? How can we trace out who are your so-and-so to ask them to come to the court and say whether you have received a notice or not? Suppose they say, I sent it to Mr. So-and-so.
Yes, in that case.
Immediately you will say he's not a friend.
No, in that case, the burden is on me. If they say, if the prima
Not
facie
unless you nominate. 48, I will not record that unless you say you nominate. Or I will record that there is no statement to the effect that you nominated someone. That will be to your detriment. Heard Mr. M. Biswas, learned counsel appearing for the petitioner. Also heard the learned APP. The learned APP has submitted that the case is culminated in a charge sheet being CS number.
Case number 74/26,
Dated?
dated 23/5/26.
Full stop. Mr. Biswas, learned counsel for the petitioner, has fairly submitted that the petitioner would approach the appropriate court praying for grant of bail. And the
Trial
present
court, my lord,
petition, huh?
my lord will mention trial court, my lord.
Before the learned trial court praying for appropriate bail, and the present petition may be disposed of granting the liberty to the petitioner to approach the learned trial court. Mr. M. Biswas has submitted that the notice under section 36 of the BNSS 2023 does not contain the signature of any witness. And though it has been recorded that it has been sent through mail, comma, the details are not reflected therein. Full stop. Should we record or should we not record on the 48th? The learned counsel has also made reference to the absence of a section 48 notice under the BNSS. Full stop. However, since this court is inclined to grant liberty to the petitioner to approach the appropriate trial court to pray for grant of regular bail, comma, the issues raised by the learned counsel for the petitioner are not decided herein and left open for the trial court to take a call. Bail application accordingly closed. I'm replied. With the liberty paid for.
My lord, there is no office note regarding service of notice. In fact, my lord, we have taken steps on 1/8. However, my lord, in the order, my lord, no notice was actually issued. Steps taken on 1st of August.
You are appearing for the lady. Heard learned counsel appearing for the petitioner, also heard the learned APP. Mr. P.S. Locker. Okay. The learned counsel submits that on the last order, inadvertently notice had not been issued to the respondent number 2. Accordingly, issue notice to the respondent number 2 in accordance with the prevalent notification steps within 2
But
days.
we have already taken steps, my lord, on 1st of August.
Learned counsel for the petitioner has submitted that steps had already been taken on the 1st of August. If the same is available, comma, steps should be forwarded to, steps should be taken upon the office of the learned PP for service of notice on the respondent number 2 list again on 26th for service of notice.
Registry may ensure that whether if
The
steps
scan
are
copy
taken-
of the TSR has already been received.
Registry may ensure also that.
That is what I've said. I've said that if the steps have been received, they'll be forwarded to the learned PP.
My lord, whether CD is required, my lord, otherwise in the
TCR.
TCR already received.
TCR received receipt, but only 183 statement is there and nothing is there apart from that.
It is
The entire
submitted that
CICD may be
only
possible.
the statement under section 183 of the victim has been sent with the scan copy of the TCR. Full stop. The reminder be issued to the learned trial court to send forthwith the case diary.
Case diary. Scan copy of the sales.
Scan copy of the case diary. Scan copy of the complete TCR. Charge sheet one.
Yes, sir.
Then
if
you'll
it
call-
is not
you'll-
searched, then we will bring the CD.
Then you strike out that part. The scan, you simply say, it has been pointed out that the scan copy of the TCR contains only the 183 statement of the accused. Full stop. The learned PP shall ensure the production of the case diary on the next date fixed.
My lord, date.
We fixed it, 26th.
Can it be?
Huh? 26th
20
August.
Item 55.
Please, your lordship, 91 days delay in filing the appeal, my lord. The steps has all taken today, my lord. We have taken the steps today.
Ms. Egan, learned counsel for the applicant has submitted that steps as required by the order dated 16/7/2026 has been taken recently.
Today,
And
my lord,
therefore,
not
today, and therefore the service of notice may be awaited. Accordingly, list the matter again on on the 9th of September
master.
with service report.
56.
My lord, steps has been taken as per the order of the Honorable Court to concerned police station.
Yes. Any report on that? No.
That will come to the record only, I think.
Respondent number 2.
Okay.
Serve the copy of.
Ms. D. Ghosh, learned counsel appears.
My knowledge, both charge sheet also is fine with this.
Okay. Ms. D. Ghosh, learned counsel appears for the respondent number 2 on receipt of notice. First up, she prays that she prays for to be supplied a copy of the petition. First up, learned counsel for the petitioner shall serve a copy of the criminal petition on Ms. D. Ghosh. Learned counsel appearing for the respondent number 2 during the course of the day. Ms. D. Ghosh has submitted that the charge sheet may have been submitted in the present matter. First up, learned APP to have his instructions on the same.
Date may be fixed, no?
List again on yes, when?
From dispute also,
Ah,
on 26th.
26.
In my, I need to file objection. Prepare.
List again on 26/8/2026. Learned counsel for the respondent number 2 would be at liberty to file the objections, if any.
Chief, can it be on first week of?
Yes. 3rd of September.
3rd of September. 3rd September. August.
Yes, please, Lordship. Lordship, the IA is for suspension of sentence. The two petitioner has been convicted under NDPS Act 20B2C for commercial quantities by Special Judge Bongaigaon. And already they,
Here, 10 years conviction, my lord. We have filed our objection, my lord, in
Yes.
IA, my lord, but it is not in the record, my lord. As per office note, my lord, 12/8, my lord. It was not here, my lord, but we have already, it was filed on also, my lord, 12/8.
You filed on 12/8.
12/8. Yes, I got the objection.
It is not on record. We'll have it on
Fine.
Friday.
Lordship, next Friday is not possible for me, Lordship, on maybe on 24 or 25 August.
List again on 25th of August 2026, along with the objections stated to have been filed by the learned APP.
Obliged.
Please, Lordship. So I have a suspension of sentence and bail, my lord. The POCSO case, the applicant has been behind a bar.
Here, second time behind, my lord, as suspension of sentence, it was rejected, my lord. Here,
Wo-
I prefer short that, my lord, 1 week time,
Wo-
final objection, my
My
lord.
lord, on the occasion 17/7 and 27, it was sought by the prosecutor to file objection.
Tell us when it was once rejected.
My lord.
What is the first
My
ground for us to consider?
Yes, my lord, the co-applicant has been granted bail by the coordinate
Huh?
appellate court. Two appellant, my lord, in this case.
We
my
do
lord.
not know we do not know the extent of the involvement in the order.
My lord, my lord.
To us, why this man,
Yes, my
why
lord.
against this man, the sentence to be suspended.
My lord, on merit, my lord.
Hmm.
The co-applicant has been granted bail by this coordinate. The coordinate by the honorable court.
What is the allegation?
Allegation that section 4 has been convicted section 4 and section 313 IPC. That's the kindly say the
10
FIR.
years conviction.
10 years, my lord. Fixed term of sentence, 10 years, my lord. But there's a vital informative. And there's no good deal of condonations. The FIR has been eligible, alleged FIR has been lost after 1 year of the alleged occurrence, but there are no explanations. And the victim is, she herself is the informant. And her age was not established, my lord. The foundational fact regarding the minority, my lord. I have enclosed all the copies, my lord, in the main appeal, my lord.
Yes, I mean,
In the main appeal, my lord.
has not been established, my lord. It is apparent from the impugn judgment, my lord.
Frame charge under section 313 of the CRPC.
Charges also framed against section 9 of PCM Act, section 498A, my lord.
My
PCM.
predecessor frame charge under section 313. Charges are framed under 313. No, not possible.
A child marriage is not true. Section 9 also, PCM Act also framed charge against the.
Madam, there I prefer for that matter to file our objection, madam, then.
By Friday.
Madam.
We'll have it on Tuesday.
Madam.
Learned APP prays for a short accommodation to file objections to the present IA. The leave is granted till 21st of August to file the objections. Full stop. Matter will be listed, list again on 25th of August, along with the objection file.
465 days as on today, my lord, he is behind about that hearing.
We'll see you on Tuesday.
Madam.
Please, Your Honor. 64 and 65 connected.
TCR is in 65, but even in the criminal appeal, I have annexed all the document for consideration of the IA for bail. Basically, my lord, I'll argue.
Are we ready?
My lord, today is for IA.
IA can do.
IA is number 360, but your lordship will take the main criminal appeal because I have annexed the statement of the witnesses and everything in the. IA, 360.
Criminal appeal IA kon ase.
In criminal appeal number 131.
Ase na? Okay. Pocket video. Yes, sir.
So your lordship will, basically I will argue on 3 grounds on this, that the IA. First is, my lord, error in sampling. Because there is a procedure how the sampling has to be done. Second, non-compliance of section 52A of the NDPS Act, especially 52A subsection 2. And number 3 is that there is gap in the chain of custody. Basically, this 3 is sufficient. One good point may also be sufficient, but let me take your lordship to the first FIR at page 27. Your lordship, the original vernacular, I have given it in type copy these days so that it becomes convenient and there is no error in translation. Nowadays, Gemini translates, but it is still risky. Page 27. Your lordship will find there are 114 bottles of cough syrup and 2 persons' name has been mentioned. Dhanjit Harma Urofe Gauhati, that is me, and the other is Jintu Sharma. Jitu Sharma, sorry. Now your lordship will kindly look into the deposition at PW1 at page 43. This is your lordship will see the page 43.
Yes.
I know the informant who was in charge of Samatha police station. These are not relevant. 2 years back, one fine morning when I came to open my pharmacy, I noticed 2 cartoons in front of my pharmacy and said grocery shop. Noticing the abandoned cartoons, 2 cartons your lordship will see. Noticing 2 cartons in front of my pharmacy and said grocery shop. Noticing the abandoned cartons, nearby shopkeepers came there and some of the shopkeepers informed the matter to the Bazaar Committee, and in turn Bazaar Committee informed police and district administration. Thereafter, police arrived and they took the cartons. Police personnel did not open the carton and I do not know the content of the carton. PP prays to declare him hostile. Then your lordship will see the cross of the public prosecutor. That is page 44. Now I am able to recollect whether I made statement before the police that police after arriving at the place of occurrence, opened the cartoons and opening the cartoons notice 114 numbers of codex in the cartoons and police sees the same. Then your lordship will see the cross. I did not witness police counting the codex bottles and did not make statement before the police that I noticed police counting the codex bottle. Now your lordship, if your lordship looks into the evidence of PW1, one thing is certain that there are 2 cartoons. And now the prosecutor has to establish first that the first attempt should be to open the cartoons at the place of occurrence to see whether there is contraband or not. This witness say it was not open and off. Now, when there are 2 cartoons, my lord, how the sampling has to be done? Here in this case, out of 114 bottles, only 2 bottles have been sent for FSL. Now, whether the 2 bottles were taken from the 1 carton or whether it was taken from the 2 carton, and whether these 2 bottles will be the representative sample of the 114 bottles, that your lordship will look into it. Now, your lordship, since he has said at page 44, the cross by the prosecution, your lordship will look into the cross of the IO or this IO, PW, page 53. Now, if your lordship looks into the examination in chief of the IO from page 53, your lordship will not find the statement which is there at page 44 when they cross by the prosecution. Because normally what happened, my lord, if a witness is declared hostile, of course the word hostile, your lordship will not find it in the Evidence Act. Because it means that the prosecution witness did not support the prosecution case. Just because the prosecution case is not supported by the witness, the Supreme Court now recently has said that you should not use the word hostile because it sounds derogatory. So the cross, normally the public prosecutor is not allowed to cross-examine his own witness. Your lordship knows that only when he does not support the prosecution case, he has to put the question which was recorded during a statement which was recorded during 161 CRPC. Now, this statement in this statement, he has put it, but he did not get it confirmed by the IO during his examination in chief. Just like putting the contradiction, when you do the contradiction, do it in terms of 145 Evidence Act. Similarly, when the public prosecutor cross-examines a prosecution witness who is declared hostile, then that same procedure has to be followed. Here, your lordship will find that it was not followed during the examination in chief of the investigating officer. So it is meaningless. Now, your lordship will see the PW2. All there's very few witnesses. Total witnesses. 7 witnesses are there. All are short. Now, your lordship will see page 45. Police opened the cartoons of 3-4 lines. Police opened the cartoons and found codex in the cartoons and police sees the same. Now, when the cartoons are open, nobody knows, my lord, how many bottles were there in each of the cartoons. And your lordship will also see, they have not, normally what happened when you see a particular type of cough syrup, or if you want to say that all the 114 bottles are cough syrup, then you have to take the batch number, you have to take some identification to show that it is the same cough syrup in all the bottles. Now, your lordship will see, police opened the cartoons and found codex in the cartoons and police sees the same. At that time, 1 cartoon was missing. But I do not know who had taken away the said cartoon. I have noticed police then your lordship will see the cross. I have noticed police taking the cartoons from the place of occurrence to the police vehicle and police took the cartoon in open condition. I heard that cartoons contain cough syrup, but do not know whether it is codex or not. Then your lordship will see PW3. The handyman of the vehicle, bus. I know accused Dhansit Sharma and he asked me to hand over 2 cartons containing medicine which will be sent to Modgharia, Gauhati. And he directed me to hand over the said 2 cartons to accused Jitu Sharma at Samata bus station telling me that the cartoons contain medicine. Dhanjit Sharma told me to drop the cartoons at Samata bus stand if accused Jitu Sharma does not come to receive the said 2 carton. As directed by accused Dhanjit Sharma, I took the cartoons from Dhanjit Sharma and carried the same in a public carrier bus. And as per direction of accused Dhanjit, I dropped the cartoons at Samata bus station. As accused Sharma, Jitu Sharma did not come to collect the cartoons from me at Samata bus stand. After dropping the passenger at Samata bus stop, bus proceeded towards Satyabari, Singra. When I reached Solmara town, I received a phone call from the police. Now your lordship will look at the cross at page 48, just the first line. They said 2 cartoons are not shown to me by the prosecution today before the court. So if you don't show the material object which was there during at the side, how you will confirm it in the court that this is the same cartoons which this witness has seen in the place of occurrence? On that day, I did not open the cartoon to see the material inside the cartoon. On that day, I did not meet accused Jitu Sharma. Then your lordship will look at PW4. This is the FSL. The parcel consisted of 2 exhibits enclosed in a sealed carton with cloth cover. The facsimile of the seal was found to be Balsor PS. 1 sealed carton with cloth covering, 2 sealed plastic bottle with 100 milliliter liquid substance is branded as Codex marked as so-and-so. The exhibit case gave test for codeine phosphate and the amount of codeine phosphate in each exhibit was found to be 194.2. Now your lordship will see 2 bottles were examined. If your lordship, if the sampling process is wrong, for the time being we say that 112 bottles may not contain this codeine phosphate. But these 2 bottles today contain codeine phosphate. And even if the percentage is 194.2, earlier it was that if it is only this 194.2 will be only taken into consideration. But after harassing case, now this 100 ml will be, if it is, even if it is mixed with a neutral substance, this 100 milliliter will be taken into consideration. Assuming but not admitting, even if you take this 2 bottle to contain codeine phosphate, then it will be 200 ml is proved so far codeine phosphate is concerned. And if 200 milliliter is proved, then if the other sampling process is defective, for 200 milliliter, I can be convicted for small quantity. Because for conviction under codeine phosphate, for commercial quantity, it has to be 1 liter. So for 200 milliliter, 100 milliliter, 100 milliliter, 200 milliliter, I can be convicted still for small quantity. But if the sampling process itself, I'm not admitting, because I want a honorable acquittal. I don't want that I should be convicted for small quantity only, but your lordship will have to look into the evidence. And there is judgment to show that if the sampling process is wrong, then this FSL report has no value. Now your lordship will see 51. During the relevant time, I was walking the driver of a bus, namely Haragori, which is used to run from Gauhati to Satyabari. Purna Boru was the owner of the said bus. On the previous night of the incident, handyman of the bus, Kanak Das, kept 2 cartoons in the bus and it was to be delivered in a pharmacy at Somata. Mistakenly, we dropped the said 2 cartons in front of another pharmacy at Somata. Then your lordship will see, police collected the said 2 cartons from Somata and showed me in the police station which contains small bottles. I do not have knowledge about putting the cartoons in the bus. It was done by the handyman. I did not see where from police recovered. So this witness has no value. The handyman told me that the cartoons were delivered in a different pharmacy. I did not have knowledge about the said 2 cartoons till I received phone call from police. Now your lordship will see PW6. Prior to lodging of the FIR on 3/11/2016 at about 10:30 AM, ASI Fukan Rajbangshi informed me over phone that an unidentified cartoon was lying in front of Prohari Medicos Chamata. I advised him to keep the said 2 cartoons out. I entered the said information in the GD entry register and I informed the matter to my superior officer. Thereafter, I, along with my staff, proceeded to the place of occurrence. Arriving at the place of occurrence, I prepared a sketch map of the place of occurrence. I opened the said 2 carton in presence of the witnesses in front of the Prohari Medicos and saw 114 numbers of cough syrup bottles inside the cartons. So he also doesn't know in which carton how many bottles were there. In the meantime, additional SP headquarter Nalbari also arrived, then this Belshop PS and deposited cough syrup. Now your lordship will see this paragraph. Thereafter, I took the seized cough syrup bottles to the Belshop police station in the same page at page 54. Seized the cup in the Belshop PS and deposited the seized cough syrup bottles in the Belshop PS Malkana. I obtained an acknowledgement received from the in charge of Belshop PS Malkana. I produced Kanak Das, that is PW3 evidence your lordship has already seen. PW7 Sonatan Borman your lordship has already seen. Now your lordship will look into the cross. This is the, I have not seen the seized articles, cough syrup bottles today in the court. I have not seen the remnants of the samples today in the court. There is no video of the charge and seizure. I did not inform about the incident to my superior officer. That is also a serious lapse so far NDPS Act is concerned. Because under 52A, there has to be photography and videography of the sampling procedure before the magistrate. If your lordship looks into the defense has been successful to show that the seized articles were not produced in the court, the remnants of the sample today in the court. There is no video of the charge and seizure. I did not inform about the incident to my superior officer in writing. That is also a contravention of the NDPS Act. Then I did not make the Malkana in charge as a witness to this case. You have to make him. I have not submitted any extract copy of the Malkana register where the entries are made for taking out and keeping the in-seized articles are recorded. It is not a fact that I have not made the Malkana in charge as a witness to this case, as this is a false case. I did not make the messenger who had taken the samples to FSL as a witness to the case. Normally, NCB and DRI don't make this preliminary mistakes. In those cases, your lordship will find that all these people will be made as a witness. It is not a fact that I have deposed falsely today at that additional SP headquarters Nalbari issued the authority letter in my favor. It is not mentioned in the Ajah that additional SP headquarters Nalbari issued authority letter in my favor. I did not prepare any panchnama of the information received from AHF Fukan Rajbangse. I do not remember whose signature I obtained in the packets of the seized article, as it is not available in the court. The integrity of the sealing procedure is also compromised, my lord. It is not a fact that I had not seized any articles in the place of occurrence as mentioned in the seizure list. I prepared the inventory before the honorable magistrate and I also took the samples at the same time. There is no photograph of taking sample before the magistrate. My lord, when the seized articles are produced before the magistrate in terms of section 52A, you have to make two inventory lists. And the magistrate has to, learned magistrate has to concur that these are the inventory which has been produced in this case. This is lacking so far this case is concerned. The inventory is not in consonance with the, now we have a 2020 rules where they have incorporated, your lordship will recall the earlier notification of 88 and 89. Now this has been incorporated, but this is an incident of 2016. So 2022 rules will have prospective, not retrospective, but those notification which was upheld by the standing orders, which was upheld by the Supreme Court in Noor Aga's case or in Mohanlal case, those will be applicable in this case. And this is not in consonance with those standing orders. It is not a fact that the accused person are not involved in this case. Then I did not collect the CDR of the conversation between both the accused person. Then your lordship will see PW7, the last witness. Second paragraph, madam. One day at about 5:30 a.m., a person sent 2 cartoons in our bus at Modghari, Gauhati, and asked us to drop the said cartoon at Samata, Nalbari. Accordingly, we take the said 2 cartons in our vehicle. I do not remember the person who sent the cartoons in our bus. I have not seen the person today in the court who sent the cartoons in our bus. Now your lordship will see the search and seizure is conducted. Now your lordship will see original documents. The seizure list and original seizure list at page 63, but the type 1 is at 61. Because except this seizure list, there is no inventory list prepared by the investigating 63, 64, and my lord, your lordship will see the one more list that is at which they want to say there is the inventory list at page 77. This is only an application made to the magistrate under section 52A for at page 77. There is no certification by the magistrate to this application, my lord. Now your lordship will kindly see.
What is that page 77?
77, my lord, when you want to comply with section 52A, then you have to.
Page 77 contains the seal of the
Page,
SDGM.
yes, madam. Your lordship will see the original. With reference to the subject cited above, I have the honor to report that I am sending here with the below noted seized articles for favor of your kind, seen and making inventory. This is only an application with a prayer. Further, I beg to pray to allow making sample of the seized article to send it to FSL Kahilipara for express, submitted for favors of your kind, perusal and necessary action. So, this is only an application to comply with section 52A. The subsequent steps are missing in this
He
case.
would not write the order allowing it on this
No,
application.
my lord. There are format. Your TCI also there. Now, before going into all those documents, my lord, your lordship will kindly see first section 52A, subclause 2, NDPS Act content. TCR to I said second case to no. 52A subclause 2. capital A, disposal of seized narcotic drugs and your lordship got it. Now your lordship will see subclause 2. Where any, those portions your lordship can omit, then you will come. Make an application to any magistrate for the purpose of certifying the correctness of the inventory so prepared. So the magistrate has to certify the inventory so prepared. This was not done in the case. The TCR is there in the item number 65. Taking in the presence of such magistrate photographs of such drugs, substance or conveyances and certifying such photographs as to. The IO has admitted that no such photographs was taken of the sampling process. Because when the punishment is so severe in the NDPS Act, that's why the legislature thought that when there is punishment is so harsh, there should be heightened security so far compliance of the provisions of the NDPS Act is concerned, my lord. Then, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. 3 is also missing in this case. Now your lordship will see, I'll place those standing orders. It is in the 2022 rules. The same standing orders is there. Your lordship looks at the standing orders of 2022. The narcotic drugs and psychotropic substance seizure, storage, sampling and disposal rules 2020. Your lordship has it. At the back end it will be there. In the same book barrack it will be there. Mine is 261, but I don't know your lordship. Same universal only. Which edition my lord is looking?
Which is the rule you are referring to?
The narcotic drugs and psychotropic substance.
The particular rule.
Yes, madam. The NDPS seizure, storage, sampling and disposal rules 2022.
Yes, sir. Rule number
10. Your lordship got it? Same procedure as per the notification, madam. Standing orders. After the sampling, after the seized material under the Act is forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53 of the Act, or if it is seized by such an officer himself, he shall prepare an inventory of such material in Form 4 and apply to the magistrate at the earliest under subsection 2 of section 52A of the Act in Form 5. Samples to be drawn in the presence of magistrate. After application to the magistrate under subsection 2 of section 52A of the Act is made, the investigating officer shall ensure that sample of the seized materials are drawn in the presence of the magistrate and the same is certified by the magistrate in accordance with the provisions of the said subsection. Now your lordship will see drawing of the sample. One sample in duplicate shall be drawn from each package and container seized. That is not there. Number one. When the packages and containers seized together are of identical size and weight, bearing identical marking, and the contents of each package give identical results on color test by the drug identification case. My lord, what has happened? Suppose 110 bottles are seized. Normally, the packaging rule is that you have to make a lot of 10 bottles each. So it is 114. So there has to be 11 lots. And from 11 lots, you have to take 11 bottles. And you have to 11 lots, you have to send it to the 11 bottle. Prior to that, you have to count in each carton how many bottles are there. Suppose in one carton, if you take the 2 bottle, you can't say what is there in the other carton. Secondly, for identification of a homogeneous nature, you have to give the particulars mentioned herein. When the package and container seized together are of identical size and weight, bearing identical marking, and the contents of each package give identical results on color test by the drugs identification kit. Madam, although the drug identification test kit, which is taken at the place of occurrence normally in the NCB or the DRI cases, but in this case it was not done. Even then, the court says that it is only presumptive. The substantive test is the test which is done at the FSL. The package and containers may carefully be bunched in lots of not more than 10 packages or containers. So you have to bunch it in a lot of 10 packages or containers. And for each lot of the packages and containers, one sample in duplicates shall be drawn. So if there are 11 lots, then 2 you have to take from those 11 lots. Provided in the case of ganja poppy, this is not applicable in our case. Now quantity to be drawn for sampling. Except in cases of opium, ganja and charas, where a quantity of not less than 24 grams, this is in again weight, my lord. The seized substances in the packages or containers shall be well mixed to make it homogeneous and representative before the sample in duplicate is done. You can also mix those 11 bottles together in one big container and send it to but here you could have sent 11 bottles. I have not done that. In case where the seized quantity is less than required for sampling, the whole of the seized quantities may be sent. Then storage of sample, dispatch of sample for 10, then expeditious test. Then your lordship will see those forms. The forms are in the back at the form number 4 and 5. In the same rules, your lordship will see just after the sections are or rules are over, then form number 4. This is form number 4, inventory of seized material under subsection 2 of section 52A of the Narcotic Drugs and Substituted Substances Act. This is the form. Then the certification by the magistrate under subsection 3 of section 52A of the. Whereas the above officer applied to me under subsection 2 of section 52A, the Narcotic Drugs Psychotropic Substances Act, to certify the above inventory and subsection 3 of the section requires any magistrate to whom an application is made to allow the application as soon as may be. I, having been satisfied that the above inventory is part of seized documents and the consignment of seized materials related to case present, will certify the correctness of the inventory. First, you will check the inventory. Then comes form 5. Then your lordship will see the certificate by the magistrate under subsection 3 of section 52A of the Narcotic Drugs. I allow the above application. This is not there. I allow the above application under subsection 3 of section 52 of the Narcotic Drugs and Substances Act 1985 and hereby certify the correctness of the enclosed inventory and enclosed photograph taken and the list of samples drawn in my presence. There is nothing on the evidence to indicate that this process was followed in standing order. First is, my lord, this is the standing order of 13,689. Now you'll also see the next page at page 26, 2.2 and 2.5. 2.2. Then 2.5 is the 10 lots process is indicated, my lord. So admittedly, my lord, in this case, so far the first step of the sampling is wrong. It is not the representative samples of the 114, the two bottles can be the representative samples of that 114 bottles. Your Lordship, I'll like
This 114 was found in one cartoon.
two cartoons.
Two cartoons.
They did not make the effort to count also in how many, because my lord, it happens because at that particular time in 2016.
But at page 54.
Yes, man.
Or even at page 53, he talks of one cartoon.
But in the evidence, it says two cartoons.
Which evidence?
Huh?
Whose evidence says two cartoons were seized?
PW1.
Eh?
PW1. PW1, PW2. And one has said that it is missing. PW 43 yes. I noticed two cartoons in front of my pharmacy and said grocery shop. Two cartoons.
He noticed two cartoons.
Yes.
Yes. Then PW2 says?
Then PW2 says. Police opened the cartoons and found cartoons in the cartoon and police. At that time, one cartoon was missing, but I do not know who had taken away the said cartoon.
PW3 says?
I dropped the cartoons.
Two cartoons.
Two cartoons.
Now, the person who takes on those cartoons at page 51, what does it say?
Page
51, no. Not page 51. Just a minute. Yes, page 53.
Page 51 also two cartoon, my lord.
Page 53. One cartoon.
Only the IO says one cartoon. All the witnesses says two cartoon. Where has that one cartoon gone, my lord? That's why we have taken that ground also. Even otherwise also, my lord, if whether we take it one cartoon, two cartoon, these two bottles can be the representative samples of the 114 bottles.
Caesar is of one cartoon.
Yes, my lord. FI also one cartoon. How do you balance it, my lord? This is the job of the prosecution, not.
Where is his application? His application was there.
And even your lordship has seen the deposit in the Malkhana, that also they cannot prove it. The Malkhana person who took custody of he was not made a witness. There was no extract of the Malkhana register to produce to show that it was deposited in the Malkhana, and we don't know where it was lying. And even the witnesses, when they came to the court, they were not shown the remnants of the sample to confirm that it was the same bottles or the same cartoon which they had seen at the place of occurrence. That much effort to, my lord, everyone has to make. If you want to send a person or if you want to convict a person beyond reasonable doubt. Now, your lordship, I'll just place some of the citation, my lord. Your lordship will first look at 2025 SCC online, 2025 SCC online, SC 1779, Nadim Ahmed. Thank you. From paragraph 26, your lordship will see. Your lordship got paragraph 26 of Nadim Ahmed. That apart, we find certain glaring infirmities, paragraph 26. Paragraph 26 will lay out the facts, my lord. That apart, we find certain glaring infirmities and discrepancy in the process of seizure and collection of samples undertaken by the seizure officer PW2. Before we delve into these inconsistencies, it is imperative to set out the sequence of events commencing from 6 July 2018 when the seizure officer PW2 received some source information regarding two individuals suspected of carrying heroin who were expected to be coming near Lakshmi store, Pragati Maidan, Kolkata with the contraband. Upon locating the suspected person, the seizure officer PW2 proceeded to search them, which yielded to the discovery of a heat silk transparent polythene packet containing a brown powder granular substance weighing 125 grams from the accused appellant Nadim, along with certain Indian currency note. A similar packet was recovered from the co-accused Amit Datta, which weighed 130 grams. Both packets were punctured and one sample each was drawn from the sample for the purposes of sealing, marking, and labeling. Upon returning to the police station, the seizure officer PW2 handed over the seized contraband to Ashish Das, the officer in charge, directing him to prepare an inventory list. The contraband was thereafter deposited in the Malkhana by SI Sandeep Datta. The investigation was subsequently entrusted to SI Debasis Borman, along with custody of the seized contrabands and the collected sample. On 20th July 2018, investigation officer PW6 attempted to deposit the samples at the officer. However, they were not accepted as they arrived after the stipulated time. It was only on 23rd July 2018 that the investigating officer PW6 succeeded in depositing the samples for analysis. While the above sequence of events appears to form a continuous change, the inconsistencies that emerge therein are such gravity that cannot be disregarded. These are as follows. The seizure officer PW2 collected only one sample each from the packets of the contraband seized from the individual accused. This is a direct contravention of clause 2.2 of Standing Order number 1 of 1989 dated 13 June 1989 issued by the Anti-Smuggling Unit, Department of Revenue, Ministry of Revenue. This said clause stipulates all the package containers shall be serially numbered and kept in lots for sampling. Sample from the narcotic drugs and secondary substance seized shall be drawn on the spot of recovery in duplicate. In the presence, here nothing was drawn at the spot. In the presence of such witnesses, panchas, and the person from whose possession the drug is recovered, and a mention to this effect should invariably be made in the panchanama drawn on the spot. Here I am not only relying on 2.2 because here it was in powdering form. That's why 2.2 will be applicable. In our case, 2.5 will also be applicable, madam. This said in standing order came up for consideration before this court in the case of Noor Aga versus State of Punjab 2014. Wherein it was held that guidelines mentioned above should not only be substantially complied with, but in a case involving penal proceeding, the rigors of such guidelines may be insisted upon. The manifest non-compliance of the standing order in the present case is therefore of considerable import, my lord. This was the observation made in this case, and our case is that there has been gross violation of the standing orders which was in force at that particular point of time, my lord. Then your lordship will look into another judgment, the paragraph 29 of that same judgment, my lord. What was?
We have seen that. Huh? We have seen that.
Paragraph 29, 30. No, yes. Now your lordship will also see a judgment of the coordinate bench of this Honorable High Court. I'll just for persuasive value, my lord, I'll place this, my lord. Paragraph 50, my lord. (52), my lord, up to 54. So let me summarize, my lord. So your lordship has seen in some places 2 cartoons, in some places, 1 cartoon. The prosecution has failed to explain this discrepancy, number 1. Secondly, they say that it has been deposited in the Malkhana. No Malkhana registered. Nobody from the Malkhana was cited as a prosecution witness. Now, so far sampling is concerned, Your Lordship, I have said that the sampling process is erroneous. It is not the representative sample of the 114 bottles. These 2 bottles can be representative samples of the 114 that has been done. Then Your Lordship will see non-compliance of section 52A. The 52A clearly says that the certification has to be there from the magistrate. There has to be photographs of the sampling process before the magistrate, and all the sampling has to be done before the magistrate. I don't find from the evidence that all this process has been undertaken before the magistrate, and there are no exhibits have been produced by the prosecution to show compliance of section 52A. In some cases, my lord, I have seen even the magistrate has been cited as a prosecution witness. Nowadays, we don't do it because from the documents itself, we can prove that the certification process was there or not.
It says that they'll be treated as proof.
Yes.
The law itself.
And
says.
when 52A, why it is important? Because it is treated as primary evidence, not secondary evidence. So for all these glaring infirmities, Your Lordship will hear it on merit. We are in custody from the
186 days.
186 days already in custody of this to convicted for 5 years.
5 years.
RI.
Intermediate
And I have not read the session judgment, my lord. I don't know from all shots where it is presumptions are drawn, 161 statement. My lord, I refrain from reading at this moment the observation of the learned session judge who has passed the impugn order, my lord, judgment and order.
They both were granted pre-arrest bail.
Yes, my lord. That also was not exhibited. The statement made in the pre-arrest bail was also drawn into this case by the London magistrate. London trial court. Well, in High Court, the lawyer makes, well, we are bound by it, but that has also to be exhibited. The person has to be put to notice. You can't do it like that, my lord.
My lord, here.
And also on the basis of the Learned Trial Court has also relied on even on the 161 statement. 161 statement has a very limited value under 162 CRPC. It is only for the purpose of contradiction or proving the contradiction or corroboration. But nowadays, my lord, after the new BNSS, we have seen in the trial court, we are facing a situation where we put the question, leading question to the IO. The IO will always volunteer. So now we have to show judgment to the trial court to refrain from recording that voluntary statement, which they quote from the 161 statement. But normally some lawyers may miss it. And this has also happened in 2016 because probably due to lack of proper training at that particular point of time. But now in 2026, of course, the situation is much more better. Now is these investigating officers are better equipped to handle this type of cases, my lord. And there are supervising officers who see that the investigation process. But your lordship has seen in the recent time for non-compliance of all this statutory notice, how many persons have to be acquitted. But in the recent judgment, your lordship has probably noted, now it says that you have to take that plea at the initial stage. If you don't take that plea at the initial stage when the person is produced, then you lose the bus. The recent judgment of, because in one of the cases, because of the Shillong case, this Shillong honeymoon murder case, in that case now the Supreme Court says that you have to take it at the very initial stage, not when the trial has started or you have already in custody and you know what is against you after the charge sheet has submitted.
Today we have dismissed one bail.
Yes, I have seen.
At this stage, he comes and says 47, 48 not supplied.
Yes, yes. I was there too, and I was lucky to hear the submission of my friends. So that's my humble submission, my lord.
Yes, sir.
My lord, here, Learned Senior Counsel has pointed several points, my lord. I will have to reply. Fix that may fix on Thursday, man.
On?
Thursday, man.
Thursday.
There is several.
We'll give him the opportunity. Thursday, Wednesday, whatever.
Wednesday, madam.
Wednesday.
Wednesday. Yes, madam. I have no objection.
I will have to check.
Heard in part.
Heard Mr. V.D. Kumar, senior, heard Mr. V.D. Kumar, senior counsel assisted by? Yes.
P. Dole Lordship.
for the appellant in criminal appeal number 131 of 2026, full stop. Your name, sir? Appears for the appellant in E2 criminal appeal, huh? E2 criminal appeal on the other criminal. There are two criminal appeals. One Mr. Bidiko and the other. The arguments of the learned counsel for the petitioner has been heard at length. Learned APP seeks an accommodation to address the issues raised and prays for the matter to be listed on Wednesday. Accordingly, listed on 19th of August.
Hard in part, my lord.
We said at length. We said that.
We are obliged, my lord, for giving us so much of time, my lord, for the bail application, my lord.
That is what we are here for.
Today only for IA, but
Huh?
today for only IA,
Ah.
but on merit.
We do not know whether we are going to decide the appeal on the next day. Huh?
PCR is there.
With the submissions which have come, whether it would result in the IA being disposed of or the appeal being disposed of.
PCR is here, and that's why we have enclosed all the statement and.
Yes, that has made our
convenience
task.
of this court, my lord.
It has made our task easier.
Well, nowadays I have also taken the initiative to type the vernacular also.
Ah.
Because if you type the vernacular, then it's easier to appreciate. Some of my juniors knows how to type in Assamese. I am that way privileged.
There was one matter in the division bench. I forget, it was somehow the English translation of the word aunt used in the vernacular. In English, it came out to be husband.
Yeah.
I think it was Mahi or something like that. But the twist of the words were such that it looked like Swami. Mahi looked like Swami. So Mahi became Swami and a lady and a boy had a husband.
And now because of AI, many of the translation are done in Gemini or ChatGPT. And again, it is.
No, the wordings of the handwriting, Mahi looked like Swami.
Oh.
So while reading the evidence, I was surprised to find that the boy was saying, I reported to my husband.
Oh.
That is when the whole case took a turn. We had to adjourn it because to have the correct translation done.
Yes.
If it is Swami, then she is a married woman who could not have been a minor. If it is Mahi, it could have been a minor who was reporting to her aunt.
Yes.
So the entire situation would have changed that day had we not noticed that it should be Mahi, not Swami.
But because of all this AI, if you can have a vernacular type copy, then it becomes easier for the AI to translate. That can be a starting point for the juniors to do a proper translation. It helps, because earlier it would take a lot of time. Now, if you have a proper vernacular type, then you can put it in the AI and have a first-hand translation. From there, you can improve. Very manual.
True, I have seen some of the AIs where if you dictate in vernacular, it is translated to
English.
Almost proper English.
Yes.
Almost.
Yes. Even for ChatGPT, you have the matter. If you type it in English, you can have a Assamese translation and give it to a person who doesn't know how to read or write English. My housekeeper now writes very good English because of this AI.
We have seen applications, everything.
Yeah. But you can make out.
Young children writing at a level which will be difficult for most master degree holders to articulate.
But if you use too much of AI, I'm told that you lose your analytical skill because it takes a particular narrative. In many of the judgment, with utmost respect to some of the judicial officers, they are using AI to take out the judgment narrative. Then you also will find that those judgments are not even reported. The ratios are something different.
AI, to the extent that it assists.
Yes, assists.
It is fine.
Yes.
The moment it starts to lead,
then
it creates chaos.
Because it goes in a particular narrative and there are lots of repetition.
And all the things this is my personal opinion, I do not know, but it has to be done on the basis of some feeding being given to it by a particular person not the prompt. When we give the prompt, that prompt is analyzed in a particular manner by a particular set of algorithms given to it.
Yes.
Those set of algorithms given by whom?
Yes.
We do not know.
But if your lordship looks into the SCC online AI, SCC online AI confined it only to the SCC volume. So you can have a check whether that ratio is there. or
When it tries to bring out that particular judgment, it depends on the algorithm
not.
given.
Yes, yes,
And how it will respond to a prompt.
yes.
If this algorithm is not given correctly to
then-
respond to a prompt, it will take you on a separate direction.
You need to have, you have to do the human research. Without that human research is very dangerous because the facts may be different. We are obliged, man.
Thank you. Wednesday.
No.
Hello. Hello.